You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University. You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. This morning we have on our docket one case, in re joint resolution of legislative apportionment. I want to announce at the outset that during the proceedings today we will be taking two breaks. We will break for 10 minutes after the initial argument of the proponents. We will break again for 10 minutes after the argument of the opponents. And then we'll come back for the rebuttal and adjourn after that.
Mr. Chief Justice, members of the court, my name is George Meadows. I'm with Gray Robinson. Along with me are Alan Windsor, Charlie Wells, and C.B. Upton. We have the honor and privilege of representing the Speaker of the House, Dean Cannon, and the House of Representatives in this matter. After 2 years of intense preparation, thousands of hours of painstaking work, the House has presented to you a map fully compliant with all of the requirements of Florida and federal law. The House recognizes and fully appreciates that Amendment 5 changed the landscape in redistricting. And it is equally true that the House had substantial concerns about how practically to implement these standards. But none of those concerns matter anymore. What the House has done in response to the standards is to develop a systematic, careful, coherent approach on how to apply and implement all of the standards. This House map does so, and does so without any nefarious intent. I know the court is well prepared and has reviewed everything, and so I would offer myself to answer any questions or concerns the court may have about the House map.
What is the standard of review that you would advocate we should apply in reviewing the legislative plan?
The same standard of review, Your Honor, that has applied in earlier times and has reiterated in 2002, and that there is a substantial deference to the legislative efforts. And that is particularly true now that there are additional standards that have to be balanced. One thing that is absolutely clear from these standards is that you have to, it's essentially a matrix of Tier 1 standards and another matrix of Tier 2 standards.
But because there are new standards, shouldn't the court have an additional obligation here? Because in previous years, we have all gone on the same standards. There has been no change. But with this new change, shouldn't the court have an additional obligation to make sure, I mean, even if there was no opponent of this, wouldn't the court have an obligation to make sure that these maps are in keeping with the new standards that the people of this state have voted for?
The court certainly has an obligation to review the maps and to determine whether or not they comply. But that doesn't change the fundamental separation of powers that this court has recognized in 2002 and before that, that the court in balancing these standards has to be accorded deference. And in particular, these standards now make that more apparent.
What exactly does that mean? I guess I'm not real sure as to what that means. If you're saying we're supposed to give these maps deference, and to a certain extent that's probably true, but since the legislature has not had to deal with these new standards before either, I think we all have a different obligation here to look at these more in depth.
I don't have any problem with the notion that the court must look at these maps in depth. Now, of course, there is a question about when that can be done and what facts and when those facts can be adjudicated.
Well, that's, I got a question. I have a question on that because I've expressed before my concern with process and how this thing is constitutionally structured and those frustrations. And now we seem to have, well, we do have, not seem to, we do have additional standards placed on top of what's there, but no change in the process. Would you share with us your view as you're getting into this about what do we do with those that I guess lean more toward a factual issue than just a pure legal issue? And I hope that's where you're going with this.
Yes, sir. I mean, both the issue of deference and the issue of what is a facial review or not. Right. Particularly now with these standards, I think the way the court should approach it and has in the past tried to approach it is if there are material facts at issue with some of these standards, then if there are disputed issues of material fact about those standards, then that has to await a full evidentiary proceeding with the ability to have discovery and all of that. There's certainly, and I'm not suggesting for a second that there might not be a map that is so obvious, that it is so defective in a particular way that one cannot have another reason, and therefore could invalidate. But with these maps and in this situation, I would suggest it's far from that, and many of these standards, most of the standards, appear to have substantial issues of disputed fact.
And so you would see that this would not have a preclusive effect with regard to as-applied kind of disputes that may arise with regard to these. Is that what I'm understanding you to say?
That is
How about
correct.
the instability that may create, however, with regard to our governing body? I mean, how does that interact?
I think there is an interaction, and there is a balancing there as well. As the court said in 2002, and struggled since the 1990s, when you have fact-specific issues that are important, the question is how can you fairly adjudicate them? The court made a common sense evaluation that you do a facial review and that a court of competent jurisdiction thereafter can decide those fact-intensive bases. I don't know how else this court does that without it doing in exactly the same way.
Doesn't that create a real problem? And I appreciate, first of all, I really appreciate the way the House went about the drawing of this map. And I think that there is, in the brief, some recognition of the importance of these standards and actually adhering to the Tier 2 standards. My concern is that have we in the past, when we've used the term facial challenge versus as applied challenge, perhaps taken the term as applied and equated it with that it needs a factual development. And I'd take an example, City of Lakeland, who will be arguing today. They're claiming certain problems with the map as it applies to Lakeland. But is it any different than when we reviewed the contiguity argument for Senate District 27 back in 2002? In other words, yes, as applied to Lakeland, but don't we have to adjudicate their challenge that the map as it pertains to Lakeland either is valid or not valid? Now, in Lakeland, I think they only attack the Senate, but
I recognize the example.
Because the Attorney General says, no, leave it all till afterwards. And to me, this would defeat the intent of the voters since 1968, and it's not fair to the citizens, it's not fair to the potential candidates, and it doesn't seem to be fair to the process.
Let me go back and explain why I think there's a fundamental difference between the notion of contiguity and some of the other notions here. Contiguity is very much a computer-driven issue and one that really doesn't have facts. The question is, once you have the facts as to where the lines intersect or where they do not, then you assess as a matter of law whether there's contiguity in a given district.
So do you agree then that if someone says, if this court says it's too hard to factually figure it out now. Whatever it might be, compactness, political boundaries, certainly not equal population, since we can measure that, and it seems to me we can measure compactness and adherence to political boundaries, that there is some preclusive effect of what we say. I mean, the Constitution says it is. It says the declaratory judgment is binding on all of the citizens of the state.
Your Honor, to go back for 40 years and to now adjudicate factual issues would be, as the court said, impossible in 2002, extraordinarily impossible now.
But let's look at what in 2002. So again, so what I'm understanding is you're saying if it's too hard, we should say it's without prejudice to this being adjudicated in a court of competent jurisdiction? But
it's not that it's too hard. It requires fact-finding and full adjudication.
So let's talk about and so you would say that tack that we took in 2002 would be one we should take in 2012.
One has to, and here's why, Your Honor. In 2002, the concern was about how do you apply the Federal Voting Rights Act. We have now the Federal Voting Rights Act. We have the analog to that in the Florida Constitution about vote dilution and about diminishment, and the Section 5 diminishment standard in the Voting Rights Act applied to 5 counties. We have that in 67 counties. That's just the first tier. Now, our opponents would suggest there's now an entirely new test with regard to what is partisan proportionality, which clearly is not part of these standards, but nonetheless, that is rife with factual issues. When you then go to the Tier 2 standards, compactness is very much at issue and disputed, as a matter of fact, among the parties here. Adherence to political and geographic boundaries are disputed.
But on those, and I understand, let's start with Tier 2. You say that, in your brief, that the purpose of compactness, equal population, and adherence to political boundaries was to prohibit political favoritism by constraining legislative discretion.
Yes, Your Honor.
And it looks like if you look at all the states that have adopted standards, an overwhelming number of them have compactness as that's the number one criteria. So it seemed to me that in terms of looking at this and saying that what is factually intense, if the House is correct, and we can look and say the House followed county boundaries and has a very strong reason why that is an objective boundary to follow. The House pits incumbents against one another. Many of their districts are compact, certainly far more compact than 2002. Wouldn't all of those actually work in your favor to say that we have been able to, we have this software to look and both measure compactness and look at the least compact and the most compact, see if there are reasons such as maintaining a majority-minority district, and say that those criteria show that there was no intent, at least facially. Would you say we shouldn't do that? Should we do that or not do that? And not even look and say that we can follow what the House is suggesting we follow?
All of those certainly work in our favor. But the question is, are there disputed issues as to opponents, or even this court? This court does not have to have opponents to evaluate it itself. But what I am saying is, if there are disputed issues of fact about those standards, that has to go through a process.
But what would be a disputed issue about compactness? Let's talk about compactness.
Perfect example. There are probably 35 standards around the country for compactness. There is no standard in Florida for compactness. And in fact, in this Amendment 5, there was nothing trying to define compactness as there is in at least one other state.
Are you saying this court shouldn't define compactness?
It is. I would suggest that it is virtually impossible to define compactness in a way that either could not be violated or will not have to change. And that is because there are numerical issues of compactness, some of which are directly inconsistent with one another. And let me give you a good example. The Roque test, which is one of 35.
I was wondering how to pronounce that.
The Roque test favors a curled serpent over a rectangle. Now, in some instances, that can have a bearing on compactness.
But didn't the House use two of the standard mathematical measures in drawing their districts?
We had in our data set 4 or 5 or 6, and I apologize the exact number, of compactness measures that took into consideration some of those standards and also took in functional compactness efforts, such as drive time, such as the ease of transportation around the district. But the law is also clear that one does not only look at numerical elements of compactness.
But are you saying that this court, in interpreting the standards the first time, shouldn't even attempt to put a definition, a legal definition, similar to what other states have done, Alaska, some of the other states, on compactness? Would it be every time that a trial judge in Leon County would define in his or her own way what compactness was and whether it was met for one challenge, and then another judge would look at the same map and say whether it was met for another challenge?
Your Honor, that to me is classic incremental adjudication of an issue that the voters did not vote on, and that is a particular issue of what compactness is. And indeed, this court can review these maps and determine facially whether there's issues of compactness or not in a factual proceeding and an appellate proceeding thereafter, just like this court does.
But isn't it also the case?
In terms, I'm sorry.
Isn't it also the case that compactness cannot be viewed in isolation?
Oh, absolutely.
Compactness is one standard. There are some other standards that are superior to that, and then there are other standards that are on a par with it. So it's all part of, I think, as you said at the beginning, of a matrix that the legislature has been given to deal with. But on this business about defining compactness, isn't compactness in this context an inherently vague term? I mean, to be perfect, for a geometrical figure to be perfectly compact, I think that's a circle.
Under some tests.
Under some tests. The one understanding of it would be a circle. Well, obviously, we can't have districts that are all circular. And under all these different mathematical tests that vary, we got different ways of approaching it. But it seems to me that all of that ends up with a conclusion that it is a vague term in this context, and that and when we look at what the appropriate standard of review is, it seems to me that that's where your argument about deference to the legislature would come in. Because if there's a vague term, on what basis do we substitute our judgment for the judgment that has been made by the legislature?
And even more, Your Honor, under Tier 1 and Tier 2, Tier 3 expressly states none of these standards take precedence over the other in that tier. It is a challenging balancing of those standards. One way to try to assess the vagueness of compactness is what the House did, and that is to look at counties as boundaries, follow counties to the extent possible, and also because counties, if one does a word search of all of the testimony in the public hearings, the word county comes up more than any other by far.
But the Constitution doesn't require you to privilege county lines over other geographical boundaries or municipal boundaries or whatever.
One can focus on cities, and rather than counties, one can focus on compactness in whatever number of different standards there might be and sacrifice county and city boundaries to some extent. And that goes to the very notion that this is an incredibly difficult balancing of standards that takes thousands of hours to do. And the real question is, if the legislature, if the House is showing a good faith effort to comply with those standards and to balance one off of the other, then that is the deference that the court must give.
In the House plan, as I understand it, you attempted to adhere to county boundaries and to not have an overwhelming number of counties in any one district?
That was a focus of the House for any number of reasons, one of which because of the population of the ideal population of a House district. And the notion was we have a vague standard of compactness. We have numerous ways it's been defined. And so where do we start? We at least start with counties.
So under your argument, it seems to me that we would have to just accept whatever definition of compactness that the House or the Senate wanted to use. Is that basically?
No, Your Honor. It is truly a fact-specific inquiry, assuming they're disputed issues of fact, about what are the standards that are employed? Do they make sense in Florida? And let me give you an example. The road test that we're talking about that focuses on circles. That is particularly inappropriate for a longitudinal and horizontal state like Florida, where you have patterns that go north-south or east-west. Circles don't work very well. Other standards work probably better in Florida. But again, those numerical ones also have to take into consideration the trade-off to a county, the trade-off to a city. Some cities are very non-compact.
But can't we tell, I mean, actually, you said something I think it was important, good faith effort. And can't we, because of the way the House went about it and what they've stated as, and this is a friendly question, so can't we, I should warn you.
I'll be the judge of that.
Can't we
beware the traps.
Can't we judge that those were good faith decisions, that they were consistent decisions as far as adhering to county lines, and again, what my concern is not that, is this idea that, which is in the Senate's brief, we've been given a Sisyphean task, which is an impossible task. If it's impossible, it's probably impossible for a fact finder, because what you're saying is there's such a great measure of deference that really, why would somebody, if somebody says, no, it should have been the city boundary, and you pick the county, and that's a good faith decision, why should that even be second-guessed in a challenge in a trial court?
Because in complying with the standards, there can be issues as to whether the compliance is pretextual and whether or not it really is compliance.
Okay, so there might be that leads me to this question. It has to do with Perry Thurston. There's an allegation that for his district that the intent was to draw it 1 block north of his home. That there is nothing in this record that's true, that happened, but also the House followed a major state road, and the districts in that area are far more compact than they were in 2002. So would you say that if we say on its face, those districts are they meet the Tier 2 criteria, and there's no evidence that there was a pretext, could Perry Thurston bring a challenge subsequently saying there was a pretext and show that maybe there was some background discussions that why he was getting squeezed out of his district?
Under the proponents, the opponent's view, results equal intent, which obviously they do not.
No, but I agree with what you're saying.
Right.
I don't agree that results can equal intent. I'm asking you that question, which is that if there's a logical reason for that district that appears to be valid, but we cannot say there's improper intent. Does Perry Thurston get to challenge that drawing of that district in a subsequent litigation in the trial court?
In part, it depends on what this court says the standards mean. Because if, in fact, the result is evidence of intent, obviously intent is a fact-specific issue depending on how the court decides it. And let me just talk about Perry Thurston a minute. The League of Women Voters maps takes Perry Thurston out of a majority-minority district. So the notion that we disfavored him is demonstrably false. Now, again, if there are not disputed issues of fact, if Perry Thurston did not raise that issue, if those issues were not raised, then that may be one thing. But every step of the way,
Well, one thing what? Can he bring it or not bring it? Because because the issue is whether there's intent with that, presumably he could. And I don't like that on behalf of the House, but I like that much better than the notion that very complex facts can be adjudicated in a proceeding that this court has said is impossible, and indeed is impossible.
Well, why does it have to be one or the other, really? I mean, the Constitution does say that a judgment of the Supreme Court of the state determining the apportionment to be valid shall be binding upon all the citizens of the state. Now, I understand various things have been said about that, why that doesn't mean exactly what it says. But I don't. That sounds pretty broad, why isn't the reality here is that we can't adjudicate fact-intensive questions because this is not a proceeding in which there's been any evidentiary hearing. This is essentially in the nature of an appellate review proceeding. We don't make determinations about facts in an appellate review proceeding. Now, if they're undisputed facts that are on the face of the record and you apply some kind of legal analysis to reach a conclusion, that's a different thing. But to the extent, for instance, on retrogression, how could we possibly second-guess the legislature's analysis about retrogression, which in the federal case law is certainly acknowledged to be fact-intensive, based on something that's in the record here without having an opportunity to have adversarial interest test various things with respect to that?
It's absolutely impossible, Your Honor. And I would suggest that if this court in 2009, in its advisory opinion, believed that what was impossible in 2002 has become possible in 2012, the voters would have had the right to know that. And the voters would have had the right to know that a appellate court is somehow assuming a fact-finding function about some of the most complex issues in the law.
Could you go back to the concept? I'm somewhat troubled. I want to make sure I understand this, that the court should not attempt to place any type of parameters through words on any of the words used in the Constitution with regard to compactness. I mean, for example, all of our core documents contain principled words: unreasonable, equal protection, I mean, you can just name them forever. And it seems to me that courts somewhere have to place parameters. And are you suggesting that unless you can have scientific, absolute certainty, that courts ought not even deal with a general parameter discussion of what that is? I'm trying to understand.
No, Your Honor, and I apologize if I suggested that.
Well, no, I don't know that you did. I'm trying to understand.
In an adjudication, a fact-specific adjudication about what is compactness in this context, certainly this court has the right to look at different standards and to try to develop the law in a way consistent with the voters' intent. But because it is so vague, because the voters did not and the framers did not choose to define it in one of the multivarious ways that it has been defined, it needs to be on an incremental basis. And the reality is this is not a process that happens every day, but there can be parameters set that will guide in the future, but it has to be based on the facts on the ground, I would suggest.
You had mentioned something about retrogression, and you said that you were able to look at how the coalition redrew his district and defeated the majority-minority composition. You were able to do that by taking the House's software program and to the map, take the statistics that is in the House data, the political data, and determine that. And certainly, and I understand we talk about things being very factually intense, but it is not at all a Sisyphean task to look at the districts and see if they, on their face, retrogress, which is took any district that had been a majority-minority district and put it below 50%. Are you suggesting we can't look and determine that?
Your Honor, I absolutely am, because the notion that one can plug in numbers and determine retrogression or not is simply not accurate. The House
I thought you said
certainly
that theirs had retrogressed and it would be impermissible.
In certain areas, and let me give you 3 examples. In certain areas, there in the league map, there are 3 districts, 20, 26, and 92, where there are existing African Americans elected and serving those communities. On the face of the map, those districts go from ones that perform down to 12%, 14%, 16%. One can assume, but let me say
so you can't tell that.
We believe that that's a diminishment. They do not.
But if we look and say that we take the Federal Voting Rights Act and say that under that it's pretty clear that going from over 50% to under post-2006 is retrogression.
It's incredibly complex. They will say at 14%, perhaps they can win in the Democratic primary, perhaps, and they might say that the minority is a candidate of choice of white voters. You have to look at racial polarization and the extent that there's racial polarization in the African American community and whether there's white-black voting in the white community, and they will vigorously contend that that is not the case. And we can say it and we can assess it, and we have assessed it, but our assessment will be viewed to be incorrect by the other side.
Well, let me ask you one other question. I know you're just out of time here, but on this incumbent protection issue, as I looked at the House map, it seems to me that you have a lot of districts that are Democratic districts that are now overlapping districts, and not so much on the Republican side. And so can we look at that, the fact that you have all of these overlapping, incumbents are now in overlapping districts?
Paired, you mean?
Yeah. I mean, you look at
two
what is now
incumbents in one
District
district?
9, which overlaps Alan Williams and Michelle Vasalinda, those kind of things. Can we look at that to determine, whether or not there is some incumbent protection here, since, actually political party protection, since not so much on the Republican side, but there are a number of Democratic districts like that.
One can look at it, Your Honor, but for a number of reasons, it proves absolutely nothing with regard to the House map. You asked for incumbency addresses, the court asked for incumbency addresses of both parties to support what they assert. They came back to you and brought one Republican saying Will Weatherford was favored as a Republican legislator. They mentioned no other Republican legislator as favored. They listed 10 disfavored Democrats.
Disfavored.
Right, but 10 disfavored Democrats is meaningless depending on how many disfavored Republicans are, and the inevitable result that when you apply these standards, people will be paired whether one likes it or not. I can tell you that given the correct evidentiary proceedings, we will show that 6 of the 10 chairs and vice chairs of the redistricting committees are paired against themselves. 6 of 11 or 6 of 10. 6 of 10 Republican Hispanics in Dade County are paired against the other. Not fun and not indicative of any political favoritism. And with that, if I may.
Mr. Chief Justice, may it please the court, Michael Carvin for the Senate, to plunge into the questions that have been asked about the standard. A couple of obvious practical points. You're not going to be able to resolve these intensely fact-intensive questions in this proceeding. So your justices have been asking, well, shouldn't we just provide some legal definitions? And I have 2 points. One is, if you try and define the Tier 2 standard, that would be quite counterproductive because, for example, your definition of compactness would not apply to the minority voting rights, which is a Tier 1 standard. Or Justice Pariente, you used the example of the city of Lakeland. It's an obvious absolute conflict. If you look at page 2 of their brief, you'll see the city of Lakeland, for whatever reason, is extremely non-compact. So you have an absolute conflict between adhering to compactness and adhering to city boundaries. What that has to be done is a reconciling process where the legislature is given the authority expressly under Amendment 5 to reconcile these things. If you try and establish some fake priority or some handcuffs that will be binding in all circumstances, I suggest it would come back to bite you. And the key point
I'm concerned that you use the word fake. Use some fake boundaries. As I understood, the city of Lakeland is that part of Lakeland is joined in almost with coastal areas. Has nothing to do with the compactness of the city itself, is it?
Oh, yes. I mean, if we had adhered to the city of Lakeland's border, in fact, if you just look at the coalition...
No, we're not talking about the city of Lakeland, it's just its border. It's just putting it within one district. As I understand the discussion, it's not that it has to be a district in and of itself. Oh, I'm missing this argument.
I may be misunderstanding their argument. I thought their argument was the city of Lakeland's boundaries need to be preserved in their entirety. And if you do that, if you look at what happens when you do that, just look at the coalition map District 10. That extraordinarily ugly protuberance is the city of Lakeland. So it would make a less compact district if you preserve their point. If they're arguing that they shouldn't have been put in with a coastal community, that's a community of interest argument, which is not in, as you know, a standard under Amendment 5. So I was just trying to make the point that these are inherently in tension. And the key point I think is important here is all of the accusations about our plan, from from incumbency protection to compactness to municipal boundaries, stem from our decisions on the minority voting rights. And if I can give you 3 illustrative examples, I think it'll make it entirely clear why their approach just doesn't make any sense. In the Northeast District that runs from Jacksonville through St. Augustine, we maintain the district at around 47% black voting age population. Now, they kept that entire district in Duval County, but the consequence of that was to reduce the minority voting age population to roughly 42%. In the face of a federal district court 3-judge finding that black cannot elect their candidates of choice unless they are a near majority. So they have reduced it to a very dangerous level, and they have done it in a way that obviously we think diminishes the ability to elect. And what was the purpose of this? Was it sometimes you can diminish minority voting population if you want to redistribute it elsewhere? But where were the other black communities that are contained in our district put in their districts? The Daytona community was put into District 7, 10% black community. Obviously, they would be deprived of all influence or all ability to elect. The St. Augustine Palatka black community was put into District 8, 9.2% blacks. My point being that you have now diminished the ability to elect these identifiable districts as well as the black community. We didn't do that, and it did come at the cost of county boundaries and compactness.
I thought their argument was basically if you have, you change that District 6 to basically Duval County district and by putting these other 4 counties, because that district not only does Duval County, it does Flagler, St. John's, Volusia, and Putnam County, that you have now taken these people in these other areas, and they now have no influence in these other districts that have been created.
That is their allegation, and the facts will prove that is demonstrably false. How have they enhanced the interest of the minorities in these other communities? That's my point. They put them in District 7, which is 10% black. They have absolutely no chance for influence.
You just said the facts demonstrate it's false.
Right.
But you're saying we can't ascertain facts.
That is why I'm here, to tell you that if this court embarks on the treacherous course of trying to decide what are admittedly complicated issues about what constitutes retrogression and how that interacts with compactness and county lines, I don't think you can help but produce false positives, either for the Senate or for the opponents. Because,
it seems to me that then it comes down to this deference that the counsel for the House talked about, and now your argument that there really is, what is the point of the Supreme Court review? I mean, it just seems to me that what we have here is an argument that says we accept what the House and the Senate has done here, and that's it. We can't define the standards. We can't make any facts. What are we supposed to do?
2 points, Your Honor. One is we're not asking for any res judicata or collateral estoppel effect on disputed facts, as I think my co-counsel has made clear. And as Justice Lewis made clear in his concurrence last, what was the logic of what they did in the late 60s in the Constitutional Amendment? This was all about equal population and things that are readily discernible. We know the population and we know whether districts connect. So equal population and contiguity is the kind of thing that they were contemplating that you did in 30 days. No rational person could expect 7 appellate court justices to resolve these extraordinarily tough factual issues, which political favoritism has bedeviled the federal courts for 25 years. The Voting Rights Act litigation fills volumes in terms of what you're supposed to figure out in terms of what constitutes racial bloc voting and retrogression. And then you have to interact those with all of the Tier 2 standards, which are admittedly new and quite different. I don't think any state has a utilized political and geographical boundaries analysis. It's preserved boundaries, political boundaries, not geographical. So I understand the temptation that we want.
Other states, a lot of states have they either require counties or I mean, there's a lot of states that have those types of provisions in their constitutions.
But we're quite different from this one, and that's the key point. In all of those other state constitutions, they say preserve political boundaries or respect political boundaries. Indeed, that was the language that the League of Women Voters offered up to this court in 2002. But they changed it in Amendment 5 from respect or preserve political boundaries to utilize political and geographical boundaries. So to utilize is not to preserve at all costs, it's to use them when it makes sense. And geographical gives the legislature a choice between respecting political boundaries or geographical boundaries.
I ask about the Tier 2 standards. Let's try to get a little definition here, because I hope you don't think that we'll come out of this opinion, whatever way we go, and just say we're not going to put any definition on the standards, and we're just going to throw up our hands. The Tier 2 standards have been recognized, and the House says it, as the purpose being to prohibit political favoritism by constraining legislative discretion. That's what the House says. Do you agree or disagree with the House's position and the position of what was stated in Brown versus Secretary of State from the 11th Circuit, that these Tier 2 standards are there actually to constrain legislative discretion so that favoritism for a political party and an incumbent is that is either prohibited or the chance of it is lessened?
I have 3 responses, Your Honor. In the first place, I think that's one of the purposes, but not all of the purposes. The main purpose of compactness and maintaining political and geographical boundaries is effective representation, i.e., people have a community of organized policy. They can go and advocate to their senator, in this case, a united front. But that could be from following geographical boundaries. For example, in the Panhandle, which we're severely criticized for, there was a huge debate between the coastal people on the north part, on the south part, and the rural people on the northern part.
But getting back, I don't know, was that your second?
No. That's an illustration. But let's talk about political favoritism. That's part of it. But let's think about how that would walk through. We have a plan that under any rational definition, including their own, doesn't have any kind of cognizable unfair result, and certainly no evidence of political intent. So if the purpose of these Tier 2 standards is to ensure against intentional political favoritism, and the result of the map is to produce a fair result, then we've presumably accomplished our purposes. In other words, let me ask one question with regard to that, because in the past, the numbering has not been an issue because we haven't had these standards. But now we have. In the past, we have not had issues with regard to numbering of the particular districts because that's not really been something to be factored in. However, now we have additional issues that we have to look at, i.e. incumbency. So with the numbering of the districts and how it affects term limits, is that something, or what is your position with regard to, is that something that now, if you look at it and say, wow, look at this, this has been intentionally structured so that these individuals will have extended terms, is that an issue that is involved with incumbency in the drawing of districts now because they've just renumbered them?
Absolutely not, Justice Lewis.
Well, why? I'm looking for the why. I assume that'd be your answer.
Number one, it doesn't come within the letter of Amendment 5. Amendment 5 says, in establishing legislative district boundaries, no district shall be drawn with the intent to favor an incumbent. So it has nothing to do with the numbers. Numbers don't affect the district boundaries in any way, shape, or form. It doesn't come within the spirit of Amendment 5 because the spirit of Amendment 5 was you didn't want to provide an electoral advantage to an incumbent versus a non-incumbent challenger. You didn't want to rearrange it in a way that would hurt them. None of that is implicated by numbering. Numbering simply says when you can stand for re-election. It says nothing about the electoral district when you're in it. Third point, all of the people subject to numbering are incumbents. You can't favor incumbents versus non-incumbents if the entire group is incumbent. It's like saying you favor Floridians.
Excuse me, I think you really can when you start looking at, if you schedule these things out. I mean, there were actually statements. I realized that people were trying to do an equitable approach, and this is not a criticism of intent or character or those individuals. I'm asking just from a legal standpoint, and you put a chart up. Yeah. And it's clear that there are incumbents who's under the term limits provision are now exceeding what the people of Florida said they could not do. But you're saying that's incorrect?
Yes, because I think that there's a conflict in what in 1982 this court said that all senators had to stand for re-election during that. So their terms were artificially truncated, not from the normal 4-year terms to the 2-year terms. So what did the Senate say? Well, if you were hurt by that constitutional provision, if your term was artificially truncated to less than 2 years, on the back end, you will get the 4-year term. We would be doubly penalizing people who were artificially truncated by redistricting if they then had to stand for another 2-year term because they're not given the term that the Florida Constitution provides.
So what happens to term limits? So the people of Florida put in our Constitution a provision on term limits.
They did, and they said you couldn't
stand. Could I finish?
I'm sorry, apologize.
So what you're saying is you cannot look to those term limits as they ultimately are applied? Is that your argument?
Not at all. No. Obviously, you can apply the term limits provision to whatever numbering scheme or Senate scheme they have come up with because that's a constitutional provision.
But does the term limits, do they apply to districts or to individuals?
No, to individuals. Obviously, the individual is term limited. He can't run
right. I mean, you can't move to the next district and then run again in that next district for another term, can you?
No, not. I mean, as I understand it, maybe the term limit is obviously the term limit provision that applies to individuals. But the length of your term in a redistricting context is influenced by whether you have an even or odd number. My only point was this doesn't erode or evade or override the term limits provision. It recognizes the term limit provisions and asks whether or not it's fair to have people whose terms were artificially truncated by redistricting to less than 4 years, and can't they be given a 4-year... We're making decisions among incumbents. We could tell these poor people, look, you only get a 2-year term this time because of redistricting, and you only get another 2-year term because you got to run again. Wouldn't it be more consistent in trying to reconcile the potentially competing instructions of the Florida Constitution to say that people who had 2 years going in get 4 years going out, and vice versa?
the first plan that was published on this was November 28th. In that plan, 20 incumbent senators were going to be given tenures of 8 years, which is what everyone thought was the term limit. 5 incumbent senators were given 9, and 4 incumbent senators, because of, again, whether they ran in special elections, were given 10. When the Senate redid its plan on December 30th, when they redid the numbering, 23 incumbent senators are now eligible for 10-year terms. 5 incumbent senators are eligible for tenures of 11 years, and 1 incumbent senator, who is Jack Latfellow, is eligible for a maximum tenure of 8 years. It seems to me, and again, you may be right, that the numbering system is not the purview of this court's review. But in terms of saying that it was done to make sure that there wasn't a poor senator that was left out, it looks like the only poor senator that got that got only an 8-year term was Jack Latfellow. Did your analysis show that to be the case?
Well, I think the key number in your point there was 23. Obviously, there's 20 even and 20 odd numbers. So the rule was exactly as I stated. Those who were in 2-year terms prior redistricting got 4 years after. Those who were in 4 got 2 years after.
But I thought that what you were saying is that somehow if it had been left like it was on November 28th, there would have been some people that would have gotten only 6-year terms. That wasn't the case, was it? Everybody was getting, no matter it was even or odd, was getting an 8-year term.
No, I think we're...
An opportunity for an 8-year term.
No, there were some people who were only going to serve the 2-year terms because they were elected in 2010 or in special elections. That's my point. Now, there was 23 of those, so you had to have a tiebreaker among the 23 because they couldn't all get the 4-year terms, right? The 23 people who had less than 2-year terms. So as to those 3 people, they definitely did say, we're not going to try and doubly penalize you. You are going to have to run again in 2 years. So you've got a 2-year term, now you're going to get a second 2-year term. Who are we going to visit that harm on, that truncation on? We're not going to visit on people who would then be term limited. We are going to do it with people who will not be unterm limited when you do the 2 years. So as to those 3, the tiebreaker clearly was, would they get a triple whammy or a double whammy? They've already got to go 2-year terms going into redistricting. They only get 2-year terms coming out. We're not going to add yet a third burden of term limiting them out. They are going to be able to run in a way that at the end of the day, because of these severely, one way to look at it is they've got to run more than everybody else. And so the idea was, the consequence of that is to give them a 10-year term because of the frequency of the election. That was all that was going on there. And again, this was choices of equity among incumbents. It had nothing to do with drawing lines in a way that favored incumbents over challengers. In terms of the general point about favoring incumbents, I want to come back to the point that they criticize us constantly for favoring incumbents, but they ignore that this was directly related to the Voting Rights Act. They make a big deal about the fact that Senator Gardner had an unusual District 10, and they claim that that was some sort of gerrymander to help him. What they failed to note is that Senator Gardner's District 10 is directly between District 12, which is the longstanding black performing district in Orlando, and District 14, which is the new Hispanic majority district that we had created at the instigance of Latino justice. Well, when you're creating minority districts, Hispanic and blacks, you need to separate them. There's a big white community right in between them. And yes, we absolutely did do that, not to have some political favoritism towards him, but in order to comply with the desires of Latino justice and the NAACP on where the minority districts will be drawn. You also asked about the rope test. I will point out that our District 10, which they claim is this horribly designed district, has a better rope score than their District 22, where they pair Senators Gardner and Simmons. They've got a 33. We've got a 46. So that'll give you some idea of what their view in terms of visual compactness and its squaring in the real world.
Refresh my recollection. Are those two majority-minority districts? Is that what's now been created?
Well, we already had an existing black district, which I believe is more like 40%, but it's obviously been performing as a black district. And we created a Hispanic majority district of roughly 50.5% Hispanic in the area, which essentially Latino Justice had drawn, and we did it. And by them doing what they did with respect to Senator Gardner and Simmons, they couldn't create the 50.5% district. So again, they keep dressing up our efforts to comply with the Voting Rights Act as some kind of incumbency favoritism. Dade County is perhaps a better example. They criticize us for separating out the white areas on the beaches from the Hispanic majority districts that we're obliged to maintain in their existing form. And they suggest this is some sort of favoritism, by the way, towards Democrats, so it can't be political favoritism towards Senator Margolis. Well, what is their alternative? They pair Senator Margolis with a Republican Hispanic incumbent. And that district, under their own analysis, is now 50% Democratic when they agree that Hispanics in that area vote Republican. So they have put a Democratic incumbent and diminished the ability to elect the existing Republican Hispanic incumbent in that district.
Well, if we go back to District 10, I guess it really is just happenstance that little area of District 10 that your opponents are complaining about is where the incumbent now lives.
You know, we can all be cynical about this, but it's not unusual for white Republican senators to live in predominantly white areas. Nor is it all unusual to separate out predominantly white areas from a predominantly black area to the north and a predominantly Hispanic area to the south. That's how you draw majority-minority districts. That's how you do it in Dade County, and that's how you do it in Orlando. But the proof is in the pudding, Justice Quince. If you don't do it, you can't create, for the first time in Florida, a Hispanic majority district in Central Florida that both the NAACP and Latino Justice were advocating. So you can elevate a naked desire to pair incumbents over creating these things, and I think the worst you can assume is that we might have done the right thing for the wrong reason, but you can't assume that either the NAACP or Latino Justice had partisan motivations, and we followed their districts throughout the state. And I don't understand how a desire to say that a Republican majority leader should be hurt would outweigh following what the civil rights groups have been advocating to us and to this court as necessary to maintain minorities' ability to elect.
I want to go back to one of the districts that you had mentioned that doesn't have a majority-minority issue, which is District 1 and 3. And you mentioned, and I know the brief speaks of the fact that you were protecting communities of interest, but you also agree that communities of interest is not a constitutional standard. The problem that I see in terms of the fact that there are, of course, two incumbents that are not pitted against one another is that the boundaries between District 1 and 3 follow everything from county lines to I-10 to minor roadways and even creeks. If you go along the boundary that was drawn, there is no discernible, principled way to get there. And I see that as in stark contrast. And I know nobody wants the House to be pitted against the Senate, but the House's very consistent application of the use of county boundaries for a very good reason, because, you know, being a part of a county is what people see as that is understood as their natural community. So I've got a problem with the assessment of that. I understand, and if the reason is not to protect the two incumbent senators, which you say you would acknowledge would be an improper reason, but to protect communities of interest. But on the other hand, the Constitution says these districts shall be compact. So you have a absolute, which is shall be compact. They're not compact. How do you respond on District 1 and 3?
3 points. Number one, to this completely fallacious notion that this was somehow political or driven by avoiding pairs of incumbents. The complete refutation of that is look at their map. They drew it north-south and preserved these counties. They did not put Senator Gates and Senator Evers in the same district, because when you draw it, Senator Evers is at the top of the county, Senator Gates is the bottom. So it had nothing to do with keeping the senators apart, notwithstanding that. Look at their map in terms of the Republican representation. These are solid Republican districts, whether you draw them north, south, or east, west. You can't draw districts in that area that are not solid Republican. So you made the point that these things are designed as safeguards against gerrymanders. My point is it had nothing to do with either of those in those circumstances. Now let's ask, what were the neutral reasons to do it? They did have a choice between political boundaries and geographical boundaries. That was a choice that Amendment 5 consciously gave to the legislature. It didn't elevate political boundaries over geographical boundaries. It gave them completely equal dignity. There is not a boundary in either of those districts that is not following a well-recognized intercoastal waterway, highway, obviously the Gulf. They do it.
No, is a creek a geographic
Yellow
boundary?
River is an identifiable geographic feature. It's not, I mean, there may be, I'm sorry.
So by giving geographical boundaries, that means that other than putting a district in the middle of a field, that you can just draw it wherever you want. And that may be what the voters intended, but is that the position of the Senate?
Again, I'll make 2 points. This is unique among the 50 states to count geographical boundaries. This is a conscious departure from what the League of Women Voters recommended this court in 2002, which said just do political boundaries. Now, it was mentioned before, you can't just write words out of the Constitution and pretend they don't exist. So unless we are going to eliminate that from the Constitution, yes, the legislature gets the choice of geographical boundaries. Now, why is that worse in the Panhandle example than political boundaries? The political boundaries do unite people in a county. They have completely diverse interests in the legislature. Some of them are rural people who have an agrarian interest, and some of them are coastal people who have an entirely different outlook. It was undisputed that the coastal would dominate the rural if you did this vertical draw that they are advocating. And it was viewed that that would not make a lot of sense, particularly since let's face it, Florida is not a compact state. It is a very non-compact state that is surrounded by water. No one would dispute that if the legislature, I don't think, if the legislature has discretion under the amendment to recognize that coastal interests are distinct from other interests, urban, rural, or whatever, that it makes perfect sense from an effective representation standpoint to give voice to that. And if you will read the compactness cases, they are not simply about shapes and numbers and scores. They all emphasize what it is about is effective representation. That is why every court has been loath to put some kind of numerical handcuffs on legislatures when they have districting decisions in front of them that make absolutely perfect sense from really any reasonable perspective. And that, I think, is the conscious decision of the framers of Amendment 5 to give the legislature the discretion when you have geographical boundaries, particularly in coastal districts, to give the legislature the discretion to utilize that discretion.
Does one look at consistency? I mean, for example, this is just absolutely, it appears, and you correct me if I'm wrong, in connection with the Lakeland situation, because that same reasoning is just absolutely contrary to what was done in Lakeland, isn't it? I mean, with that long strip that goes over towards the coast?
I think that was another effort to try and have
I mean, it's absolutely contrary to what you're saying. I mean, do we have consistency in application? Is that something we should look to, or it's just in one situation you'll do it one way, in another situation you do it a different way?
And if you had a full trial, where you could walk through regions of the state, engage in that kind of fact-intensive analysis, you might expose our efforts here as pretextual. I don't think that's true in Lakeland. I think you'll see a relatively consistent pattern, again, in the balancing test, that if they had an option for coastal districts, which admittedly, under these numerical scores, are a little bit less compact because they tend to run like this rather than like that, the Senate's choice, when it made sense, was to actually unite people who have common interests in front of the legislature. They didn't do it to the detriment of anything in Amendment 5. I think Lakeland's complaint, you know, sometimes population, you have to go out a little bit farther than you otherwise would. Polk County is where Lakeland is.
Okay, I think what my question is really more fundamental than even that. It is there a consistency of application of reasons that a court would look to determine validity? You understand what I'm saying? Whether it happens to be Panhandle or Miami, but is there a consistent? This seems to be an inconsistent logic, is what I'm saying.
No, I think you can certainly expose any inconsistencies to show that our presumption of good faith is we're no longer entitled to. That's fair game in a trial proceeding. I just want to make this point on Lakeland, though. That's in Polk County. It's one of those areas of the state. It always happens when you draw maps that the population converges there. They criticize us for breaking Polk County 4 times. Again, their alternative map breaks it 3 times. That's because that's where the population tends to wind up. The only reason they don't have the 4th break in their map that we do is because, again, they didn't create this Hispanic majority district. We went into Polk County to get some additional Hispanic population out of it to, just as Latino Justice had recommended, get us up to a majority district in Orlando. Again, you look at these things in isolation, you don't get the full picture. You need to understand how these maps are drawn. Unless there are further questions. Thank you.
Right. We thank you. The court will now stand in recess for 10 minutes.
All right.
minute and 52 seconds remaining.
Supreme Court of Florida is now in session. Please be seated.
Sir. Mr. Chief Justice, members of the court, my name is David Theriak, represent the city of Lakeland.
Now you have 10 minutes, right?
Yes, sir, I have 10 minutes.
Sorry, the time needs to be reflected as 10 minutes here.
Thank you, sir. With me today is the city attorney, Tim McCausland, and our associate, Chris Bush. Let me begin by thanking the court for providing the citizens of Lakeland with an opportunity to be heard today. As you all know, the city objects because the city's boundaries have been bifurcated. It is our position that that bifurcation constitutes a violation of the requirements of Article 3, Section 21, which mandates that districts shall, where feasible, utilize existing political and geographical boundaries unless the Tier 1 requirements preclude it.
Now, the Senate, are you attacking the Senate and the House, or just the Senate?
The Senate, ma'am.
The Senate's argument is that because the amendment says, first of all, it of course says where feasible, you would agree with that?
Yes, it does say that.
That because it says political and geographic boundaries, that the Senate really, that the voters gave the legislature the discretion to pick and choose really any boundary that they want as long as it's a geographic or political boundary. What is your how would you advise us, first of all, interpreting that particular provision, give it some meaning in accordance with the intent of the voters, and then how does that, though, apply to your particular challenge?
I'll start with the second question first because it's quick. I don't see anything in the record that the Senate relied upon a geographical boundary when they bifurcated the city of Lakeland. So from the city's perspective, we don't see anything that applies to the city. But we agree that this court should provide a definition for geographical boundary. I don't know of any definition that exists. I would submit to the court that it must be more than a geographical feature and that there is a distinction between a boundary and a feature. Perhaps a geographical boundary, when used in the context of a city or a county, is a lake that splits the city. But there must be something more than a creek or a road. If the standard is a geographical boundary will be construed as a creek or a road or a stream, basically you've rendered that clause a nullity. There would be no standard. There'd be nothing that would hold either the Senate or the House's feet to the fire. Now,
their argument, though, for Lakeland is that there was no nefarious purpose, no intent to favor or disfavor an incumbent, that Lakeland you had to start someplace in the state, and Lakeland happens to be in the middle, and it just, if they had started differently and started with Lakeland, maybe there would have been another community that would have ended up being split. And of course, I would add, there are in the Senate map as well as the House map that followed county boundaries, there are splits of cities. It's not possible to keep every city or county together. So what's your argument on that? How do we, if they say, no, we did it in the drawing, and unless we redrew the whole map, we can't help Lakeland?
Yes, Your Honor, we think they should redraw the whole map. There is nothing in the Constitution that states that the political boundaries shall be utilized except for the point of convergence.
I guess in terms of this, many of the states, and I've looked at every state to see how they do it, a lot of them consider alternative maps not to see, because they don't have to pick the best map, they just have to pick a map that is constitutionally valid, but to prove a point, you have the challenger establish the map. Now, and again, I realize there's probably limited resources, whatever, but the only map that we received was from the coalition, and as was pointed out, there's some issues with the coalition map. So how do we, in terms of the burden, you would agree, first of all, you have the burden to establish, or do you agree with that you have the burden to establish that there was a violation of the constitutional standard?
I believe the legislature had the initial burden to demonstrate in the record that there was a basis for splitting Lakeland. And when we reviewed the record, Your Honor, We saw nothing in the record that indicated that Lakeland needed to be split in order to avoid favoring or disfavoring an incumbent or a political party. We saw nothing in the record that it was necessary to split Lakeland in order to avoid interfering with the voting rights of minorities. We saw nothing that indicated that Lakeland had to be split to maintain the contiguity requirement, nor did we see anything in the record that was required for the one person, one vote requirement.
So what about the presumption of validity? I mean, I guess, and we'll talk about that with the challengers, but don't we actually start out presume that the maps are valid? And so you're saying, well, they still have to, we have to be able to look at the record and see and understand why they drew it that way. And their argument is we drew it that way because we started in one part of the state, and when we got to Lakeland, it was the only way that we could draw it. And if we don't see that, you say, no, there was another perfectly fine way to draw it that doesn't sacrifice anything, that doesn't split Lakeland, then we've got some evidence of that. But short of that, I don't know how we can, I feel badly for Lakeland, but how we can recognize that type of challenge in this type of proceeding.
Our viewpoint, Your Honor, is that it wasn't the city's obligation or this court's obligation to draw the map. That is the first responsibility of the legislature. And there should be something in the record that demonstrates that the decisions that they made were based upon the constitutional requirements that Section 21 imposed upon them.
Mr. Theriak, I understood from your opposition's argument that they needed to pull numbers from your area, your concerned area, over toward the east for that district. What is your argument in response to that? That was a substantive argument I understood them to make.
What I heard them say, Your Honor, was that they needed to pull numbers from Polk County. The fact that they needed to pull numbers from Polk County doesn't mean they needed to split the city of Lakeland. There's nothing unique about the city of Lakeland that precludes the city as a whole being included in one district. That's our point.
The population center of Polk County, Lakeland, I would imagine, Bartow and Polk County also?
Lakeland, Your Honor, is approximately 97,000 citizens.
So, I mean, if you're looking for population to distribute it, that seems like to me the best place in Polk County that you would find population. And the 2 points that the counsel for the Senate made today really supports the arguments that we've made in our brief. They state that they made decisions based upon effective representation. They state that they made decisions based upon protecting coastal from rural. Yet those two arguments are the arguments that we're making by bifurcating the city of Lakeland, which is the largest population center in Polk. Lakeland citizens have had their effective representation diluted. The bulk of the population has been placed in a district that extends all the way down to the coastal areas of Manatee County. Their votes will be diluted in comparison to where the majority of the population is in that county. The majority of the population is going to be concerned with coastal issues, not interior issues. In light of Jimmy Buffett being here last night, it's coastal Jimmy Buffett. In Lakeland, you could call Johnny Cash. It's just completely different. The part of Lakeland that's in this particular district that includes the coastal, you're saying makes the Lakeland voters, the bulk of the people are someplace else. Is that what you're saying?
The portion that was included in the district that extends down to the coastal areas of Manatee County included approximately 62,000, 64,000 citizens out of the 97. So you have 64,000 combined out of 470 versus having 97,000 in a district of 470, which is your magic number for the equal population in your districts. And there was no rational basis. We looked at other areas around the state, and you have instances where you have cities abutting cities abutting cities. That's a different situation where at some point you are going to have to split a city, particularly in an urban area, because you don't have any unincorporated area that surrounds
what was
a particular city.
In 2002, or since then, has Lakeland been in one district?
No, it was split in 3. in
So
02.
They'd say that you're doing better. Maybe by 2022 you can get into one.
Yes, they would say we're doing better, but in 02 there wasn't the constitutional requirement to utilize the political boundaries, and it doesn't say if you do better than 02 but still split a city, you're okay.
You know, I understand that you don't have to show improper motive, but for a facial challenge, I mean, this was an area that Senator Dockery represented. She's no longer in. Is there anything on the record, though, that points to any improper motive? They may not have gotten it exactly right, or maybe you say they got it wrong, but you look to see, well, is there something that they did for an improper reason? Is there anything on the record that would support that?
First, Your Honor, I don't believe that Section 21 requires that there be an improper purpose to find a violation that a political boundary wasn't utilized. And I don't see anything in the record that indicates that there was an improper purpose. But there's also nothing in the record that justifies splitting Lakeland. And my time is up. Thank you.
Mr. Chief Justice, may it please the Court, I'm Paul Smith, representing the League of Women Voters, Common Cause, and the Council of La Raza. 10 years ago, the legislative leaders of the Florida Senate and House were in federal court and openly admitted that they had passed a map with the two district maps with the intent of maximizing the advantage of one of the two political parties. 2 years ago in Florida, the voters passed amendments which expressed their intent that that kind of practice, which has unfortunately been a feature of this state for a number of years, should no longer be possible. That instead the legislature should be required to pass maps that will be responsive to the will of the people, as that may change over time, rather than maps that decide in advance the composition of the legislature based on how the lines are drawn. The legislature, of course, fought tooth and nail against this reform over a period of several years, and then this year decided that it wouldn't make serious attempts to come into compliance with the new obligations. And this is particularly true, with, as Justice Pariente commented, with respect to the Senate map, which has a whole series of clear violations, I would submit, violations sufficiently clear that they can be found even on the limited evidence that is available to this court in this abbreviated proceeding. Evidence which includes many of the same things courts look at all the time to ascertain legislative intent. Evidence that is also in many cases statistically undisputed. The maps themselves, their statistics, the legislative record, the admissions that have been made by the House and Senate in their own filings in this court. And what that evidence shows is that both maps, and this is essentially undisputed on the information before this court, both maps build in a very significant advantage to the Republican Party over the Democratic Party, even if the voters...
Let's analyze that a little bit. The constitutional amendment doesn't draw criteria along those lines, and if we have that the partisan representation of one group happens to live in a particular area and the others live in other areas, I mean, it's inevitable that as you draw the lines and comply with the other criteria, that you cannot look to your particular partisan registration for that constitutional analysis.
Well, Your Honor, I was really beginning to make the point that there is clearly an imbalance in the maps, in the sense that they're gerrymandered, in the sense that if 50% of the people vote for one party and 50% vote for another party. I realize that's not a violation by itself, but it's evidence that goes into the mix that this court can consider. And then what else should you consider with respect to the Senate map?
But can we let's just stay on that one, sure. Because you make some of your points are, well, they fought Amendment 5, and I don't see that as being a useful legal reason to show intent. I mean, they have a right to have said, we don't think we can, whatever reasons, it doesn't seem that is something. I understand you've made that point, but I respectfully don't see that as being indicative of the intent. We've got to start with that there was good faith, in my view, on the part of the legislature. But the part of the partisan imbalance, when you take and say that the state is, there are more registered Democrats than Republicans, yet in the last races, statewide races, Republicans have won almost all the statewide races in 2010, and as Justice Lewis said, The problem is, and I think it's been demonstrated, is that the Democrats are concentrated, I don't think anyone would dispute it, in South Florida. So you can't, no matter what you do, you aren't going to make districts 1 and 3 Democrat. Do you agree with that?
That I agree with.
Okay. And there are many parts of the state that and that's not, I know that your group has been a proponent of good government, and I appreciate that you're not, you're not the Democratic Party, so I appreciate that where you're coming from is you want this process to be fair. So in that regard, though, my concern for using partisan imbalance is just what Justice Lewis is saying. How can you really say that when, in fact, the Democrats are clustered in cities and in both, in and some in around Orlando, but mostly in Southeast Florida?
Well, here's what we put in the record, Your Honor. We put in the record evidence that says, how do these districts function if you split the vote 50-50? We did that by putting in an average of the Obama-McCain result and the Sink-Scott result. When you average those together, very close elections, you basically have a 50-50 result. And we said it's an F1 in our appendix. How do the districts function in the Senate?
What about, I think the point is, what about all those other statewide elections that were very different? Well, how can, you've picked certain elections that show something else, but the reality is there are a lot of other statewide elections. I reject the whole premise of this because of the notion that has already been articulated about the demographics of the state, the way the voters are kind of residentially made decisions about where they're going to be, and that's going to result in some different allocation than you would have statewide. But even your argument about statewide performance seems to me to be fallacious because you picked 2 races, you said here, when there are a lot of other races where the Republicans won.
You're misunderstanding me, Your Honor. We are not saying that we think that the map should produce 50-50 outcomes. The reason I was pointing to a 50-50 test is that's how you figure out how much bias is built inherently into the map. So you look at those things and you say, if the voters split 50-50, which is not how they usually vote, how many districts does one party gain over the other at a 50-50 point? And the results that are shown is the Republicans get 24 Senate seats, the Democrats get 16 Senate seats. So there's that much advantage built into the map, irrespective of whether people actually vote 50-50. Now, part of that is the geography, and I can address that, but I'm sorry, Your Honor.
There are approximately 3 million people in the state of Florida registered to vote, but not registered to either Republican or Democrat. And that's about 25% of the total. How have they been considered anywhere?
The way that our analyses work is we look at how people vote in particular places, precinct by precinct, and analyze how they voted in the past statewide elections to use that to predict how that particular unit of geography will perform in the future, not how they're registered. I think registration is a reasonably uninformative thing compared to, it can help you analyze the distributions, but it's not really predictive of anything in terms of how people actually vote.
Where is the analysis that how the presidential race perform would translate into a Senate state race?
Well, the experts would tell you that that's how it's always done. You use statewide results. We use lots of them, governor's races, Senate races, president races, but you have to use a statewide race because...
Is there any historical basis for that here in Florida?
Your Honor, historical basis for whether people in a particular place will vote Democratic both in statewide elections and in local elections? Yeah. Absolutely. I think I don't have the analysis done. We didn't do that, but there's a way you do that.
You didn't do that?
No, we don't have that in the record at this point, but you correlate precinct by precinct, and you'll find very, very high correlations between voting for legislative races and voting for...
Going back to the fundamental question, if this is not one of the elements that we are told by our organic law to consider and use, then, we're really talking about a non-issue, aren't we?
Right. Your Honor, let me move to the second point I wanted to make about the Senate map. Is that these outcomes, these disparate outcomes, are not an accident. For one thing, you have to look at what they did on incumbents. And the incumbent treatment, I submit to you, is so clear that even in this proceeding, you pretty much have to conclude that they acted with a primary focus on favoring incumbency. There are 29 non-term limited incumbents in the Florida Senate. every single one of them received his or her own district leaning in the direction of their partisan views, their partisans. Basically, each of them got their own safe district to run in. The chances of that happening by coincidence are as close to zero as anything can possibly be statistically. Not only did they each of them get their own district, each of those districts, those 29 districts, kept 69% of their prior territory. The other 11 districts kept 50% of their prior territory. So they were focusing on keeping those districts the same for the 29 non-term limited incumbents. So given those facts, there has to be, I think, I submit, in any rational world, sufficient evidence to conclude that the Senate was focusing on favoring incumbents. We also have in the record how this happened. Senators talked at the hearings about how staff went from senator to senator and said, what would you like your district to do? We're having some trouble here. We may have to move it over here. Would that work, or would you rather it went south? And they said, the Senate says, well, but we didn't have political data we were using in that discussion, senator by senator. But that discussion occurred, and the senators know which territory they would rather have if they have to move.
Is this relevant to your argument about districts 1 and 3 over in the Panhandle?
Well, certainly, Your Honor, I don't think there's any doubt that those two districts were kept almost identical to how they had been in the past because the incumbents wanted to keep their territory.
But what's the problem with this? What violation? Point to me the violation of any standard that districts 1 and 3 have. I mean, because basically, as I see the other map, it's making those districts vertical as opposed to horizontal. District 1 is all along the coast and covers, 4 or 5 counties, and then District 3 is along the northern part and covers basically the same counties, maybe with a couple of others in it.
Right.
And so what's wrong with that if it doesn't violate any of the other provisions of Section 21?
There wouldn't be if it didn't, but it does. And I think a very important piece of the second tier provision in Section 21 is the compactness requirement. And what you have as a result of the way they divided those districts is, particularly District 1, is 150 miles long and just a few miles wide. It's extremely non-compact under any sort of normal understanding of what that term means. And what our map shows is you could obviously do two fairly wide rectangles right next to each other, keeping counties whole. But that is a non-compact district. And a lot of what happens in the Senate map is to ignore compactness without any justification in Tier 1 or in federal law, simply saying we would like to not have compactness be a requirement on us. And so you look at...
So you're saying that all the Tier 1 criteria can be met and compactness,
yes,
if you do this map do these
absolutely. The way they do the congressional map and the House map, you could have done the Senate map, and it would be much, much, much more compact.
Now, what standard would you articulate to govern the compactness evaluation? Is there a specific numerical test that you'd say this is the test we should look at, and if it goes above or below a certain threshold, then it's not compact? Or is it that combined with a visual examination? Or what specifically? How would you articulate it as the standard?
Your Honor, there are two recognized tests, as the United States Supreme Court has pointed out several times. It's the REOC test, by the way, not the ROC test, and it's Polls v. Popper. And those are the ones that typically are used. I think you can combine a certain amount of visual understanding, and there will be situations in which I think there is tension between compactness and following city lines, like the city lines of Lakeland are not very compact. We saw that in a map. And so in some situations...
Well, but what about tension between that and following other geographical boundaries?
Well, I suppose it could be. I'm not sure I'm prepared to suggest, to disagree with Mr. Theriak. I don't think that should be every creek you can find somewhere in Florida.
Well, okay. Well, we'll stipulate that there might be some things that would be asserted to be a geographical boundary that we would decide would not be.
Right.
But is there anything in the amendment that the people adopted that privileges the compactness standard over the ability of the legislature to follow geographical and political boundaries?
Absolutely equal to all of those things, but there are going to be situations, and we have clear examples of it in the Senate map, where they're very, very low on compactness, and there's no available argument that it was done to keep geographical units together, or because they were equalizing population, or because of Tier 1, or because of federal law. There simply aren't. If you look at the districts in Orlando that Mr. Carvin was discussing, he made the rather remarkable claim that those districts were required by the Voting Rights Act, but that is just flatly untrue as a matter of law, and you can look at the undisputed facts and draw that judgment. The African American district, which he mentioned, District 12, was 33% African American voting age population as drawn 10 years ago. They increased it by making it very non-compact to 40% African American voting age population. The Voting Rights Act does not come into play under the Supreme Court's Bartlett decision until it's 50% citizen voting age population. So that district cannot be required by the Voting Rights Act. It may be a good idea. Everybody thinks there should be an African American district. We drew it in a compact way that keeps it 33%, so there's no retrogression, and there's representation of African Americans. But to suggest that they should draw that thing that wanders all over that region, crosses between or Orange County and Seminole County in multiple places because of the Voting Rights Act was simply untrue. And exactly the same thing is true of District 14, which wanders a little all over the place just south of there. They don't have the level of Hispanic population that would trigger the Voting Rights Act, which is 50% citizen voting age population. They don't have that there either.
Your opposition posits that what we're looking at is effective representation. And when we look at Districts 1 and 3 in the Panhandle, that this is effective representation, that the different interests for the coastal areas, vacation, tourism-oriented, and with the more rural areas, I guess it's homes and some of those other counties up there. What is your response? I realize it's not a criteria of the Constitution, but it's the overarching principle that we're looking at.
That's the essence of my response, Justice Lewis. It might be a good idea as a matter of policy, but the whole point of these amendments and the reason the voters supported them is to put some discipline on the legislature. And so for them to be able to come into the court and say, well, we didn't care about compactness here because we thought it would be better to have the shoreline better because they have more in common than the rural people, is to say, well, essentially we're going to dilute the imposition of some relatively important handcuffs on the legislature. This is about the people telling the legislature you can't keep doing it the same way. And so we're going to put some rules on you that try to discipline that. And I think it's important that those be enforced as written and not they be watered down by whatever good government argument somebody else might make about some other value that's not reflected in the amendment.
I want to get back to something you said about the Tier 2 standards. You said that among Tier 2, they're all equal. And then there may be tension. And
sometimes.
Clearly, for example, in the House map, by following the pretty consistently county boundaries, there was population deviation. Do you accept that something like following county boundaries as a good thing that may, an important thing as a recognized boundary, may affect equal population?
I absolutely do think that, Your Honor.
Okay. Now, the next thing, though, that you said was that they're all equal, but I'm questioning and reading Tier 2. It says political, let me just make sure because I want to make sure I have this here. It's that it says that it has to, that they are to use existing political and geographical boundaries, where feasible, but that it says for compactness requires the districts shall be compact. Now, to me, shall, under plain English, is a command that is, unless it violates unless it's necessary for Tier 1, it's got to, compactness actually is the first of these Tier 2 requirements. Can you explain? Otherwise, it doesn't mean anything to say something says where feasible. It doesn't say compact where compact unless you want to respect communities of interest.
Right. And I don't really disagree with what you say. I think every district has to have a reason why it's non-compact.
But the reason has to be, to me, something in Tier 1, not a choice. And, you know, we're going to be interpreting these provisions for the first time. I just want to make sure if I've missed something as to that command shall be compact.
The only thing that I would add, though, I think there will be some gray areas where things are a little bit less compact because they follow the city lines or county lines, and that ought to be tolerated for the same reason you tolerate a little bit more population deviation because of the other ones there. When something is really non-compact, then I think that's a violation unless it's required by federal law or by something in Tier 1.
Now,
that's absolutely right.
They said on 1 and 3, when you follow county lines and draw it vertically, that the two incumbents still get their own districts. Is that, I mean, I don't know that, but is that...
It did come out that way. We didn't look at incumbency when we drew our map, Your Honor.
So it may or may not.
The line we happened to draw through that central county, I forget the name of it, of the 5 in a row, it happened to not have them paired. That wasn't an issue that we were focused on. We are not interested in forcing people to be paired. We're interested in following the rules that are of the game that have been set by the people, the voters of the state of Florida.
So your argument on 1 and 3 would simply be that they cannot use as an excuse communities of interest to sacrifice compactness for that. But
right.
And then on political and geographic boundaries, there's Mr. Carvin says that their geographic has equal stature with
right.
political boundaries, and that therefore geographical boundaries can prevail if they want them to.
Well, first of all, let me just intersect a comment. I think it's really important what we're doing here. The court needs to establish what these things mean so that it's not up to the legislature to decide what they mean. And so what you have here now is a sensible interpretation of what that requirement means from the House of Representatives, which is to say we try to keep cities whole, we try to keep counties whole, and an interpretation by the Senate, which is effectively designed to nullify the requirement, because if you can go from city street to city boundary to town boundary to stream to county boundary, you can draw any non-compact, any district you want that doesn't reflect any kind of a sense of community. That requirement makes no sense. So I would really urge you to say, let's not read this language woodenly in a way that will eliminate concerns about what this was really about, which is let's try to...
It's about a sense of community.
It's about keeping cities and counties whole if you can. That's what it's about. Yes, Your Honor.
How would you then...
Obviously, one of the reasons that's a good idea is because they have community. People have a sense of community in those places.
The argument's been presented this morning is that the other types of things should be in a category of geographic features. What is your position with regard to the parameters of geographic boundaries in our Constitution that this court should consider?
You know, you're obviously writing on a clean slate here. If you ask me, I would interpret that thing to focus primarily on city and county boundaries, and that where there are...
But wait a second. It specifically refers to political and geographical boundaries. So I don't understand how you can say that geographical is meant to refer primarily to political.
No, I was going to add, Your Honor, that there are situations in which there are going to be geographic features that happen to also function as divisions between communities,
right.
Like a significant river that people doesn't have a bridge at that place. If they want to use that and explain that's what we did, I think that'd be fine too. But you know, they shouldn't be able to just pick anything on the map and say that's why we drew the line there, because wherever you draw a line, there's something.
But again, going back to if one were to express what this concept, political geographical boundaries, what do you suggest as the defining parameters that can be stated in a realistic way that have an understandable impact?
Well, I think the goal primarily ought to be keeping cities and counties whole in the way that the House did. And that when there are use of geographical boundaries that are not contiguous with political boundaries, they ought to be things that they can, in good faith efforts, say we view this as a real boundary. It's not just a feature. It actually divides communities in some way. And this is all, as Justice Perriensi said, about being able to come in and make a good faith showing that we tried to do something that makes sense. And the Senate's way of applying this doesn't do that. It just says we can wander all over the place as long as we can find something to be on the edge.
In your map, did you and I may be wrong on this, so correct me if I am, the Senate District 14 is drawn by the Senate. They created a majority-minority Hispanic district.
Well, they say majority-minority. It's actually 41% citizens of voting age population because many of the Hispanics there are not citizens. But I think they say in their appendix it's 50.5% voting age population. Many of those people are not citizens.
And yours goes to what percentage?
Your Honor, ours, which is District 19 on our map, which you can see is just in the southeast corner of Orange County. The figures on that one are 43.7% Hispanic voting age population, 36% Hispanic citizen voting age population. So it's a little lower. And, obviously represent La Raza. We're not against the creation of a community, a place for Hispanics to be represented in Central Florida. This is something that's very important. I think it just should be done consistent with Section 21. And so we have a district there that's quite compact in one county and will grow, if it's not already, it may already be an effective Hispanic district, but it will be certainly in 5 years with the growth of population.
That's not a district that's a created district, so that's not one that under Section 5 of Section 5 is we have to be concerned with unconstitutional retrogression.
There was no Hispanic district at all there before. That's
question
correct.
I didn't ask, but I believe we're all on the same page on this, but I just want to make sure. The purpose of the Section 1 Tier 1 requirement of the districts shall not be drawn with the intent or result of denying or abridging equal opportunity of racial or language minorities to participate in the political process is to put into our Constitution the equivalent of Section 2 for the first prong and Section 5 for the second prong. Is that how you understand it?
It's very clear that Section 5 is what's being incorporated on the second prong. Let me get to the Section 2 question in a minute, but if I might, on the Section 5 piece, I think it's really important to understand what that means. It doesn't mean you can never lower the minority percentage in an existing minority district. It means you look at it functionally and ascertain, this isn't laid out, for example, in the NAACP comments, it's in our briefs. You do it the way the Justice Department does it. And if a district is 55% African American, you may very well draw a district that's 46% African American. It'll still be very clearly a district in which they have an ability.
Isn't that a highly fact-intensive inquiry? And if the legislature has made certain judgments about what needs to be done to avoid retrogression, how in this proceeding, where there is going to be no adversarial testing of evidence, could we enter into a judgment that requires that kind of fact-intensive analysis that would supplant the judgment that's been made by the legislature?
It may very well be a fact-intensive one, Your Honor. We are not making a claim of violation of that provision. I would note...
But you are asking us to second-guess the legislative judgment about what they must do to comply with the constitutional requirement, aren't you?
Well, in principle, I would. I think that should be enforced.
Well, I think in principle you're asking us, but you're also in practice asking us to do that. For instance, with respect to the district in Jacksonville, in that area.
And all the way down to Daytona.
Yeah, well, Jacksonville, starting in Jacksonville, yes, I should say. But it's your position, if I understand it correctly, that district should not be drawn the way it is drawn.
Right, and I think that may be one of the more fact-intensive issues we've brought to your attention.
Okay, that's a fact-intensive issue, but how can we make that evaluation on that fact-intensive issue to second-guess the judgment that the legislature has been made? I just don't understand how we could enter into that kind of functional analysis that you say is necessary in the context of this 30-day proceeding where we have no evidentiary proceeding.
I would note that that's exactly what the Department of Justice does routinely in a non-adversarial administrative review based on exactly the kinds of expert evidence that we submitted to you. And so if you think, you obviously have some discretion about whether you want to become the Civil Rights Division of the Department of Justice.
Well, this is a court.
Yes, Your Honor.
This is a court. This is not the Department of Justice. We function as a court functions.
Absolutely, but that function that they exercise is quasi-judicial in the sense that it's replacing what happens in the District Court of the District of Columbia, which is the same issue, looking at whether or not there remains an equal number of districts in the state in which there's an ability to elect. Could be something you could do. It might be something you would rather defer. But in this case, one thing you need to do is make sure you interpret it correctly. That it's not that you can't reduce the percentage.
Yeah, I want to make sure about that on the interpretation. And if I'm wrong about this, you're going to correct me, and then we'll hear from the other side.
That's what we're here for.
I thought under Section 5, first of all, Section 5 under the Federal Voting Rights Act. Nothing we're going to do here is going to supersede Section 5 under the Federal Voting Rights Act. But that it requires, since 2006 and the subsequent interpretation, that if you have a majority-minority district pre-2012, which is over 50% from a voting age population and a functional analysis, that you cannot go below 50%, and you say no.
No. That's exactly what the functional analysis looks at. What the Justice Department does, and this is laid out in what's called the DOJ guidance on Section 5, which is cited at page 26 of our brief, is they have a concept that a district either gives you an ability to elect or it doesn't, and they recognize that many districts with a minority percentage in the 40s range gives an ability to elect because every day, every election, that group will be able to nominate their candidate of choice and elect their candidate of choice. And they would never deny preclearance because a district went from 55 to 46% African American if they're convinced that the 46% is a sufficient level. So that's what the functional analysis looks at. And for you to say that the percentage can never go down in those districts when those districts were a linchpin of the very gerrymander that was stipulated to 10 years ago would be unduly rigid. And I think, so if you happen to be sending this back to the legislature to deal with the fact that they were obviously favoring incumbents, for example, I would ask you also to clarify that keeping those districts exactly the same is not required by Section 21. It's not required by Section 5. It has to be looked at functionally. You just have to make sure that statewide, as the NAACP brief says, there's an equal number of ability to elect districts judged functionally.
Now, ability, there's the majority minority, then there are influence districts, and then there are there's coalition districts.
Well, that's the way Justice Department looks at it. Either you have an ability to elect your favored candidate, which very often will be a person of your own race, or you don't. And so it's a dichotomous thing, and influence districts are not what we're talking about. We're talking about districts in which the favored candidate of the minority group predictably will win the election, both in the primary and in the general, and that is a yes or no. It's not a matter of degree, and it occurs somewhere in the 40s in most places for African Americans because they are very they tend to vote together. It might be higher for Hispanics, for example.
You say somewhere in the 40s,
yeah.
But now in the district that starts in Jacksonville, hasn't the voting age population been reduced from 47 some odd percent in the legislature's map to 41% or thereabouts in the map that you proposed?
42, I think, is the number. Yeah.
Well, okay. Now it might be said, well, that's a marginal change, but elections are decided at the margin. And I'm still grappling to understand the theory by which we would second guess the legislature's judgment in that sort of arena where obviously there is something at stake that the Constitution was designed to protect.
Well, you might find it too fact-intensive to do in this proceeding. I understand that, but that's not something that a court is incapable of assessing. There's expert testimony. There's elections.
I'm asking about this proceeding. What we have to deal with is the case that's before us now.
I understand it's not my position, it's not my organization's position that you should decide every possible claim that could be brought against these maps in this proceeding. But you do have evidence and you do have real requirements that need to be enforced. And when you can determine that those have been violated, as with the compactness requirement, as with the incumbency favoritism requirement, I think it's incumbent to do a little bit of a pun there on the court to act when it can. I think you have to recognize the limits of the evidence you have. We don't have discovery. We don't have cross-examination of experts. I acknowledge all of that. But there is sufficient evidence here, at least with respect to the Senate map, that they didn't do this in any way trying to be fair. The idea that Mr. Carvin would stand up and say there's no evidence of an unfair result or of unfair intent in a map where they gave 29 out of 29 of the incumbents, most of whom are from one party, a safe district to run in. So we know all 29 of those people are going to get elected again in 2012. That's not consistent with the amendments, and I think you have to, when you know that, and it's effectively undisputed, you have to take action in this proceeding, or this whole exercise we're going through will lose its meaning, which I think the people were counting on this court to take action when everybody knew what really happened here, and that's what we have, particularly with respect to the Senate map.
You agree that in the past, the numbering of districts has not really been one of the matters that we have been concerned with. Yet now, one of you on your side raised the specter of that being a problem, and the response is no. This is not the drawing of any districts. It is simply the application of a number, and this is the direct effect of what's happened with regard to the elections, and somebody's going to have a 2-year term, et cetera, and so on. Why is he not correct in his analysis of this, that really that aspect has not changed?
Well, it's a textual issue whether or not you see the numbers, which are a feature of the map, after all, as being within the purview of the anti-incumbency favoritism provision or not. I think that's kind of a close question textually. The main reason we were introducing that into the discussion, though, Justice Lewis, was that it's such a powerful additional piece of evidence that the motivating factors, the things that were driving the Senate process, were making sure every senator had a district to run in, they kept most of their territory, and they all get a chance to be there for 10 years, except for poor Senator Latvala. This is not an incumbent free process. This is a process where everybody got to discuss what they wanted, got what they wanted to the extent they could. This is the same process we've been living with in this state for many, many years. They didn't try to do it any differently in the Senate side. The House deserves a considerable amount of credit. Our main concern with the House is this profession of we didn't look at politics, and therefore that's all we do is avert our eyes, and that should be the right way to handle it. Our position is you should have to look at it and try to, where possible, within the constraints of the geography and demography of this state, which are constraints, be equitable to the parties.
I thought the House, in fact, in their software, that's how we were able to obtain political data, that they did, unlike the Senate, actually understand the DOJ guidelines, and those are built into their software, isn't it? The political data?
My understanding is they had the data in their software and that the Senate says it didn't, and that may well be true. But they also argue that they satisfied the no partisan favoritism rule because they just didn't think about
the House
effects.
Says that, or
the House, both sides say that actually.
But we have evidence that the House, again, that the House, by using the county lines, that there are incumbents pitted against one another,
sure,
that there is, if you look at the compactness versus 10 years ago versus today, that there, especially in the areas in Southeast Florida, that they're more compact. I mean, so those, I guess, and that brings me to a question I have. If we were to find that the Senate map has problems, is invalid, but the House map that challengers have not met their burden,
right,
is that something that you understand based on the Constitution, is that the judgment can be that it's severable, that the joint, I think the House says yes,
the House
it
has
is.
a citation to the severability clause in the resolution, which I think was designed by the proponents here to allow just that to happen, and I think that would be the appropriate way for the court to handle it in that situation. There's no reason to send both of them back if only one of them you think has been demonstrated not to meet the constitutional standards. I would urge you also, if you decide that the House map hasn't been shown, we haven't carried our burden with respect to the House, and I understand that the evidence is not as strong, to not preclude some additional trial level type.
See, and I understand. I've got some. I know you sort of agree with the.
Everybody wants to make
House.
sure that
you want to have it. It seems that puts this process into for now for the constitutional standards. It was one thing in 2002 when we were talking about Section 2, Section 5 Voting Right Acts and a equal protection political gerrymandering. But now these standards are in the Constitution. We need to review them. If we say, but you can also bring them later if you have some facts to develop, gives no certainty for anybody.
It seems to me that, given the puzzle that you're facing here, you ought to have three categories of things: things you can determine are violated, things you can determine are not violated, like contiguity, and things that you just can't decide. And, it is somewhat in tension with that last clause of Section 16, I realize, but you've been doing this for 40 years now, saying we just can't decide this. And as a matter of the federal Constitution, we can't preclude people from...
certainly not the federal Constitution.
Well, not even a state constitutional claim that hasn't really been adjudicated. Due process would suggest.
But let me refer back to the provision that we talked about earlier, which is in subsection D of Section 16, where it says a judgment of the Supreme Court of the state determining the apportionment to be valid shall be binding upon all the citizens of the state. Now, that's in there.
Yes,
and that's talking about this process that we are in now. And I do not understand how, for claims other than federal statutory or federal constitutional claims, which obviously can be off the federal court any time, how for state law claims we can say that they can be raised in subsequent proceedings. Maybe we'll have a litigation around the state challenging various districts I just don't know how that can be squared with what that part of the Constitution says.
Right. I understand the problem, but we have issues like the one you raised before, where you said maybe we can't decide whether or not District 6 could safely be reduced to a Duval Cody.
But this is the process the people have established, and they have said that this process has preclusive effect.
Well, but it can't be the right answer to say to the opponents of these maps, we can't decide your claim because we don't have enough evidence. But by the way, once we don't decide it, it's decided for the next 10 years. You lose. That just can't be the right answer.
But on the other hand, it seems very troubling to me that after we've said that these things are valid, or that's what we say, then later on, if there is a challenge, and that challenge is found to be valid, then what happens? Then you get to reapportion over again?
Well, that's a fairly common thing, that people bring claims under the Voting Rights Act, and they have to redraw the maps, and if the legislature doesn't do it, the courts do it. That's the way it's done, yeah.
It just seems to me, I could understand doing it as a part of this, a month or so from now, or 2 months from now.
Yeah.
But a year from now, after it's gone through, a trial court proceeding, it's always a little...
You have some difficult challenges in the way this was structured, for sure. I see my time has run out, Your Honor. Thank you.
Mr. Chief Justice, may it please the Court. My name is John Mills with Boies Schiller Flexner. Accompanying me today are Joseph Hatchet with Acreman Center and Alan Neliver with Boies Schiller Flexner. The Court's asked a series of questions about standards, and perhaps Justice Kennedy and I were the only people that read that subsection D, and I found that very interesting as well. In the context of our standards, which were created in 1968 in terms of review, and Justice Periente mentioned we've been doing this since 1968, and in that record it was Senator Jack Matthews who wanted the Florida Supreme Court to be the reviewer of the reapportionment plans, because he wanted the Florida courts, rather than federal courts, to be the decision maker. So from the very outset, this validity review was critical. So there's a question. What is the extent of the validity review, and what are the implications of determining that it's valid? Validity is not defined, and this Court has changed its mind a couple of times about how much you should consider. In 2002, it was quite narrow. You're now confronted with a different situation. This is a question of constitutional interpretation. And in terms of standards, one of the most interesting things about deference to the legislature is that at its essence, this is an interpretation of the Constitution. The court interprets the Constitution. If the legislature interprets it, they have to defer to you. They have had to interpret these provisions of Section 21. That's their duty. But you are the ultimate authority. So their interpretation may be interesting, but your interpretation is binding. So it seems to me that on the constitutional interpretation issue, the court is supreme. If there are certain issues that relate to drawing maps, they may receive deference because that's a legislative function. But on the constitutional interpretation, it's the court. Now, on this issue of validity, there is actually, I'd cite the 82 decision pursuant to this consideration, where the court said, this holding is without prejudice to the right of any protester to question the validity of the plan as applied in appropriate proceedings. We retain exclusive state jurisdiction to consider all future proceedings related to the validity of this apportionment plan. That seems to say that there could be future proceedings.
In that opinion, did that court so much as acknowledge the provision in the Constitution we talked about earlier? There was no mention of that. It was
no.
Like it wasn't there.
So I certainly understand what you're saying. That provision says what it says. And you have to figure out what the implication is. And I think that if you determine some component of this is valid, you'll need to interpret that. You'll need to say whether it means that's the end of all proceedings. And as Mr. Smith said, if you're going to do that, then your interpretation of the role of interpreting validity should escalate. I mean, in other words, if you're deciding this for all time, then you've got to consider whatever you need to consider to see if it's valid. The term valid isn't modified either.
Here's a problem in terms of the process, and Justice Lewis talked about it in 2002 before the new amendment, is this 30-day period. Looked at states that have original jurisdiction. First of all, and again, I know hindsight is wonderful, but the legislature in this state reapportions in almost a year after they receive the census data, and no matter when they get it to us, we've got this 30 days. Other states, like what we did in 1972, 1982, 1992, is by retaining jurisdiction, it's up to this court then to decide if enough had been raised in a challenge to let it go to a commissioner. And so we retain the ability to decide if there was enough there. So I'd almost say that the declaratory judgment was interpreted as being we're deciding facial challenges, but we're leaving it within our bailiwick to go back. But we have the 30 days. No one suggested go ahead after the petition was filed and send this to a commissioner to decide any issue that's been raised that could be factual issues. So so in terms of the process, since no one did suggest that, are you suggesting that we should go back to 1972 and say that we retain jurisdiction to allow factual challenges to be brought?
I'm saying you can do that. You are the ultimate interpreters of the Constitution.
We know perhaps what we can do in terms of we've done.
If you're going to declare it valid, there are two options. Nothing, and it's valid, and under state law, that's it, which seems a strange implication if there's serious dispute and everyone's saying that the issues and the facts are unsettled. That seems a strange result. So you can make that interpretation, and if you're going to declare it valid, you should. Now, one of the interesting things about this process is if you look at the process as it is designed and you may have to live with, one of the options is to send it back. Now, would it be all bad to send it back when all this dispute exists?
Send it back to the legislature.
To the legislature. In other words,
the predicate for doing that is that we declare it invalid.
You have to declare it invalid. You have to declare it invalid, but one part of your declaring it invalid would be we don't know enough to declare it valid.
Well, I mean, that's a very interesting argument, but I don't think that we can change the process by which there is a presumption. I mean, to me, and you tell, I mean, I see this as that there's a presumption of validity, and the challengers bear at least the initial burden of showing a basis for invalidity.
I cannot see how there's any presumption of validity in their necessary interpretation of the Constitution versus yours.
So you're saying if we find that a...
If you decide to define the Constitution, which I hope you will, in detail, and your definition is in conflict with what they have used as a definition, then it seems to me that's invalid.
Okay, so that would be a basis.
But what that does pragmatically is the legislature this time operated in the dark. They necessarily didn't have your opinion. At a future time, they could have your opinion and follow it.
Well, so would you agree that if we declare one of the plans invalid, that in doing so, it would be incumbent upon us to articulate the clear reasons for that and to explain very clearly how the features of the plan that caused it to be invalid could be corrected? And again, it would have to, I think one of you said in your briefs, one of the objectors said in your brief that that was part of the task if we were to declare invalidity. Is that your understanding?
I'm not sure if you should, or if you're obligated to tell them precisely how to redraw it, but you should tell them what's wrong with it and define the Constitution so they could reasonably return.
Well, certainly we don't tell them how to redraw it because we have a process for that eventuality. I mean, so it certainly can't be that, can it?
No.
Okay.
No, I mean, you reach a conclusion, and if you reach a conclusion of invalidity based on any of these definitions, it goes back. But again, the benefit of that is they now operate with a constitutional interpretation, whereas before they were obligated to operate from simply the language which they themselves and many have said it's ambiguous, we need to flesh it out.
But what about the factual? I can understand your argument if you're talking about an interpretation of the Constitution. But if there's really a factual problem, it seems to me that sending it back to the legislature isn't going to resolve that factual problem, is it?
Well, if you say, for example, one of the things that would be elemental to define would be intent to favor. That's intent to favor or disfavor. One of the parts of the most important parts of the proposal was to deal with favoring or disfavoring a party or incumbent. So
a party. It doesn't say a party, does it? Doesn't it say
plan? So if you define intent to say there are factors that can indicate whether that intent, what intent is, and those could include several things. But let me first say that the importance of defining intent can't be overstated, because the fundamental premise upon which this was passed was to try to create or establish or foster plans that would be more nonpartisan. So what does intent mean? The law does intent all the time. We don't allege that there's evil intent on the part of anybody, and you don't have to establish it. What you have to establish the best you can in interpreting intent is how do you infer intent from actions? Because you're unlikely to get a mass confession that there was something wrong. So if intent means anything, it has to be defined.
So how would you, so let's get to the meat of this, since you're suggesting that we define, I'm assuming you're going to, we need to define each of these. How would you then define intent? And that is, define it in terms of how it can be, how it's established and how it should be prevented.
Seems to me that you get certain indicia based on actions. And those could include a political imbalance, and you've seen that. Either registration or performance, you have to decide if you think that's influential.
What would be the benchmark for determining the imbalance?
In terms of facts. The benchmark,
I assume you're talking about performance in elections.
Yes.
Okay,
yes.
But how would you go about establishing what the range of elections would be that would establish a benchmark?
Well, first of all, you have to consider if that factor's enough. But if you say that factor's enough, then you could establish benchmarks statewide, and you...
Well, you tell me what it should be. I'm asking what you would suggest that we use to establish the benchmark.
The benchmarks that have been used have been statewide elections, which indicate the overall partisan balance. Now, you referred to the compression factor, which is called the Tobler effect. If you've read that proposal in the House, and the House has mentioned it, which means that Democrats are more compressed. So if you draw a compact map statewide, Republicans are advantaged. So,
do you dispute that?
No. What I do suggest is this, that actually the prior knowledge of that indicates that I know if I'm going to draw a compact map, it's going to be skewed. Partisan fairness is a Tier 1 issue. Why shouldn't you make the same effort you make with the other Tier 1 issue?
Because I guess on that one, every court that speaks about how you draw a map that doesn't have a favor or disfavor of partisans says that if you adhere strictly to compactness, to recognize political boundaries and equal population, you do not in this state have to, there is not a requirement like there is in Arizona, that you have to make it politically neutral. All that is required is that it not be drawn to intentionally favor it. So I have a real problem if you're now saying that they shouldn't first start with observing the Tier 2 requirements as a way to assure that the Tier 1 intent is met, especially if it's because of where Democrats live. I mean, they're not going to bust Democrats up to the Panhandle, are they?
The actual language in Tier 2 says unless it conflicts with Tier 1. But Tier 1 is race and partisan fairness.
But I don't know, how can you have an intent to favor that is based on the fact that where the geography is, you said that where the compression factor, the natural, that if a commission, there was at one time that if a commission was drawing this, that they might come up with something reasonably the same, maybe not for 1 and 3, and not for 14, and not for 6 and 9, and not for the ones down in the southeast, but overall that they would come up and Democrats would not, under anybody's neutral view, have a majority of these districts.
You don't have to and can't compel perfection. All I'm suggesting by the statement I made is this study indicates that people are knowledgeable about the impact. There's a second really...
But what you're suggesting from that, if I understand you correctly, is that subsection A, in the language that that the plan shall be drawn. I'm sorry, they shall not be drawn with the intent to favor or disfavor a political party, would then require, once you have the knowledge about the compression effect, then to give effect to that language would require that the legislature actually make compensations in drawing lines that would actually help make up for the compression factor. Is that what you're suggesting?
That you have to consider the compactness is subservient. If you have something that is not compact, that is drawn with the intent to favor or disfavor, then you have to change it at the sacrifice of compactness.
Well, again, maybe I misunderstood.
I think I've said it the other way.
I thought you were suggesting, though, that in essence, because of the impact of the compactness factor, that the other things would have to comply with subsection A. The legislative body drawing the lines would have to understand that that's going to, to the extent that they're compact, it's going to favor the Republicans, and would have to do other things to compensate for that. That would basically there'd be a countervailing effort to balance it to favor the Democrats. Is that what you were saying?
Well, to invert that and say that to know that drawing this compactly will intentionally favor should be considered. I mean, that's.
What are your other factors?
There would be three factors, and the second factor really relates to political packing. We've talked about racial packing. Political packing in a shorthand is if you had 3 districts of 100 persons each. And if half of those, 150 were Republicans and 150 were Democrats, and you put...
Help me with the notion of independence. Your co-counsel, as I understood, said that basically party registration is meaningless. I'm not sure that's your position at all. It seems to me 3 million people, how they register to vote is a fairly meaningful process to them.
I think the focal point of most of this is performance, which would include how independents vote.
But wouldn't that go one way or another? I mean, it just seems inherently to me if somebody chooses not to register in either major political party, they keep their options open. Perhaps they vote one way in one election and another in a different election.
I mean, indeed they do, and that would show in performance. So you would have a district, since we still have parties, and so this is assessing the performance in a district of the parties, including the votes of the incumbents.
But it seems to me that in many, perhaps most, of the districts, the elections are going to be decided by whoever is an independent margin.
And that may well be.
So
but that would be included.
If that's true, then how can the Republicans here be favored when it's going to be decided by the independents?
If the decisions, there are 2 pieces of data: the actual district line and the performance in that district. And of course, one can argue about what you put in, but the actual performance includes what independents did. And if those independents help Republicans win by 25%, that's what that district will show. Even if, say in the Panhandle, if it's Republican, even though it's a Democratic registration, so it'll be Republican performance. So to emphasize this packing issue in my 3 districts, if you put 75 individuals from one party in one district, then you guarantee the success of parties in the other 2 districts, and that's political packing. So the question is that accidental? How did it occur? I'd refer to those of you who like graphs. In the coalition brief, I, too, has a very good representation of what the dispersion of districts are. So the effect of political packing clearly is to favor. So you have to determine if you think that should be a factor. Third factor is population deviation. So that is, if you have a party that you don't like, you put their districts are overpopulated, essentially diluting them. So you have to consider if you think the overall performance standards, that again is not performance standards, that is reviewable. You can look at all the districts and say, how were they distributed? Now, I want to talk about the racial.
Just one, before you get to finish with this, the intent. My problem with what you said about the, using compression factor to show that there was an intent is that Arizona has in its constitution that to the extent practicable, competitive districts should be favored. And this is a different standard than what was chosen in both the proposal and then adopted, which is not effects, but unlike as you're going to move into the minority protection, which does deal with effects, but it does use intent. And so I agree that intent has to be shown. You're not going to get the smoking gun comment, although, again, as we talked about in the numbering, Senator Latvala might say, well, what'd you do to me? The fact is that we've got to look at objective factors. If you finished with the ones that, before you go actually to individual districts or anything, that you would say are factors that would go into intent?
Well, I should mention actual record evidence or comments. I mean, there are comments on the record that could indicate bias, or
and
at least.
What would those be?
Well, it could either be knowledge or bias. For example, I mean, if there are statements on the floor.
What are? I mean, we got the whole floor debates.
There are floor debates. What were they? The floor debates in both houses on the last day asserted these very facts, that they were biased. So you could disagree with it.
Again,
you can disagree with the argument.
I mean, the opponents of the plan asserted that.
Right. And you could, as a proponent, disagree with that, but you can't say you didn't hear it.
But we could look at the process of drawing the maps where the House had started out, they had 5 maps, and they, in their committee, they would talk about, well, this one's more compact. You know, there was a process that, where, I mean, we can, or should we look at all the process? I know there was somebody arguing that because they didn't show the map to the public, that indicated a lack of transparency, and then there's others that say no. So is there anything about process that would go into our analysis?
I would only say if it fits into this standard of actually showing an intent. The fact that there's a good process or the fact that there's a bad process, unless it contains something that indicates favoritism, should be neutral. You've got the plan. It's up to you to judge the result, and in doing so, you have to interpret these terms. Was there intent to favor or disfavor?
What do you say about the fact that in the Senate plan there is no incumbent pitted against another incumbent? Your colleague said something about that was virtually impossible unless there was the intent. What do we say about that? Because again, in the House there are incumbents, and they mention even incumbents that are high-ranking Republicans that are pitted against incumbents.
You could conclude that's a factor. I mean, again, I say that's up to you. You've got to conclude how you define it.
We need help. Okay,
Then I think you should do it. Glad to provide any other.
That's helpful.
Thank you, Chief Justice. I appreciate your support. On the racial fairness issue, This is, of course, critical. It's Tier 1, 2. Both of these are top factors in the Fair District's proposal. So I think you've universally decided that you need to define what it means. Now, there's been reference to Section 5, et cetera. One thing I think it's important to note is that Florida now has its own standard. You're not compelled to define this precisely the way anybody else has. You can use it, but it's your constitutional language.
But isn't the language in the text here actually drawn from the central provisions of the Voting Rights Act, including subsection 5 of the Voting Rights Act? I'm sorry, Section 5 of the Voting Rights Act.
The words are similar, not identical, and so certainly you can do that. What I'm suggesting to you is if you wish for this to mean more, in some senses, like if you want to suggest that these standards should be more concerned with issues that were of concern to Florida, like racial packing, which has been mentioned. In other words, a way to dilute minority votes is to put too many in a district.
Is that what about District 6, which is what one of the, I believe the argument is that that's what went on in District 6 by going through and picking black populations out of all these counties, that they overpopulated District 6.
This actually brings me to precisely one of the issues with these plans that you could determine invalidity without going any deeper. Both of these plans, according to the proponents and according to their lawyers, have defined this provision as saying we don't retrogress at all on percentage, right? And they should, I'm sure you'll ask them this question. Was that your standard? We don't retrogress at all based on percentage. You also heard them, and you heard others, and you see all briefs say that you have to actually evaluate the effect. The absolute percentage is not the correct test. In other words, do we think that 50% in 2002 means the same thing as 50% in 2012, that 50% in 2022? It will not. No, we presume that people and voters act differently, may be less cohesive, may be easier. So if you're concerned about not diluting the ability, you don't need to guarantee 50% perpetually.
Is there a case you could cite us under Section 5 of the Voting Rights Act where there's been a significant, a reduction of the voting age population of the minority group, where it was possible to not reduce it, where that has been upheld based on the functional analysis, where there's actually been a reduction in the voting age population? I know there are cases, and I think we've been cited a case where it said that the maintaining the voting age population is not necessarily enough. You may have to do more than that because of the functional analysis, but do you have a case where you could show us where based on the functional analysis, an actual diminution in the voting age population has been upheld?
I don't have a case in front of me, but that's the test.
Do you think you've cited a case that does that?
I don't think we've cited a case that does that.
Do you think you looked for a case that did that?
Say again?
Do you think you looked for a case that did that?
We probably did.
And didn't find one, right?
But, Your Honor, what's the standard? I mean, the question is, you just said maybe the percentage ought to be higher, right? Well, maybe the percentage ought to be higher. They didn't evaluate it.
You're saying the percentage ought to be lower.
In terms of their test, it doesn't matter.
Well, who didn't?
They didn't do it.
Who didn't? Wait, let's just go back.
The House and Senate, neither one did the extensive voting analysis that's described, that they actually describe from time to time. That is, you're supposed to deal with cohesion, racial cohesion, white voting cohesion, etc.
So you're talking about the functional. You're talking about the functional analysis needs to be.
They didn't do a
made.
functional analysis.
I thought the House did a functional analysis.
Well,
no,
they can say that.
Okay. Now let me on the functional analysis, because this still, I understand exactly what you're saying on Section 2, and I think there is a difference in terms of when something is being used affirmatively as a sword, which is a Section 2 challenge, versus it being a constitutional guideline, which is we want to maximize the ability of minorities to elect candidates, minorities, racial and language minorities. The concern I have, and it was brought up by your colleague, and I need to go back to this, because I had thought that the way Mr. Carvin talked about Section 5 in his brief was the correct way under Section 5 to analyze retrogression, which is that if the district was a district that was over 50%, and it was in a covered jurisdiction, this would be under a covered jurisdiction, that you
which
could
would
not
be limited
go
in Florida.
You could not go below 50%. Am I incorrect about that? You can't
My understanding of the analysis.
Let me just finish. Those would be pre-cleared under the Department of Justice standard for the covered jurisdictions of Section 5?
Those would be, the Section 5 in Florida would be pre-cleared, yes.
If it went from a district that had been 53% and went to 45%? I mean, I'm not
voting
talking
age,
about
population, performance, etc. I mean, Justice Perriente, I'm glad and I'm interested to hear the responses of the proponents. In other words, if they considered all of those factors in defining those districts and did the ecological regression analysis and did all of those things and then determined that that percentage was correct, then that's reasonable.
I see. So you're saying
I'm saying that what they did was insufficient. If you say in the Florida Constitution, you're going to define the Florida Constitution to say what does this mean? What does it mean? Shall not be drawn with the intent or result of denying or abridging equal opportunity or to diminish their ability to elect. I mean, yes, there are other standards, but that's up to you. It's the Florida Constitution, and you can define what diminish the ability to elect means.
And so you're saying because they didn't go through at least the correct functional analysis that the Department of Justice in its guidelines sets forth, that they can't say, well, we did it because we drew these districts that just happen to be, have all incumbents in order to help minorities when they didn't go through the correct analysis. Is that your argument?
Yes.
Okay.
And that you have to perform a functional analysis. And as we go forward, what is the definition? I mean, you're entitled now to define that. And it seems to me that if we're just talking about the future, do you think it's best for Florida to guarantee that any district now that's 50 to 52% minority will always be? What if it changes? What if it only takes 35% to elect a candidate of their choice, and the data shows that? Aren't they? What about the rights of the other people, the minorities that are being, quote, packed into that district that could have an impact in an adjacent district? You've got to think about that. You have to deal with that definition. There would be one last point, and that is one of the most basic points, and that is equal population. There's new language in the Florida Constitution on equal population, and it says shall be as nearly as equal as practicable. Now, that's the same in the congressional article and in the legislative article, because of previous interpretations in the congressional districting has been interpreted as 0.
Previous U.S. Supreme Court.
Previous U.S. Supreme Court, and all states operate to comply with that. there's been more flexibility on state plans, but not unless you're using that flexibility for a reasonable purpose. In other words, the reason that flexibility was installed was to allow states to seek racial fairness and fair districts related to race. So if you're not doing that, there are cases. Now, the Larios case in 2004, which went to the United States Supreme Court, if you are not using that margin for reasonable purposes, including to advance the causes of minority districts, you don't have a safe harbor. So you've got to go back and look and see if that means basically zero. If so, there's a problem. I would conclude, Your Honor.
Can I, before you conclude, because you didn't mention how we're going to define compactness and political and geographic boundaries. Do you have a proposed definition, or do you agree with the proponents that the term compactness is so vague that it's really not even capable of being defined?
It's capable of being defined, and you're capable of defining it, and I think...
And how would you define it?
You can define it as relating to rational standards, which could include the ROAC test and other tests. But again, one of the things that I'm suggesting is very important here is the legislature operated without your interpretation. Now we are talking about interpreting all of these
And
provisions.
what about on political and geographic boundaries? We've got the House that's saying the county lines are the most important lines in their drawing of the district. The Senate says it says political and geographic boundaries. They're equal in the Constitution, so we can equally find, if we find a geographical boundary, it can trump a political boundary. What is your view of that? I mean, how we would interpret it?
The language says utilizing existing political and geographic boundaries. So in the text, it's equal.
Is Eglin Air Force Base a boundary that's acceptable under the Constitution?
I'm not sure. I mean, Eglin Air Force Base might be a federal boundary. There might be some ways you could define that. But I'd like to conclude
it's federal territory.
That's right. So it's got to be a boundary, I guess. But I think that that isn't what this says. It says, and I presume those are political and geographic boundaries unless it's federal territory, maybe so. But your options are, it seems to me, in any case, you're going to interpret these provisions. And if you interpret these provisions, what happens? If you simply declare it valid and that's the end of all inquiry, that doesn't seem to me to be a fair outcome. If you declare it valid and say, there's some things we didn't know, but these are the new standards, proceed somewhere to do that, and we'll be the ultimate reviewers anyway. You can say it's invalid. And if you say it's invalid, it actually has a relatively rational public policy response. I mean, you go back to the legislature that now has your interpretation, and they can, whether their efforts were, assuming their efforts were in good faith before, they can be in good faith again, but more informed. Thank you.
All right. The court will now stand in recess for another 10 minutes.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University. You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Yeah, I know. How's that? In other words, I start at 15 and when I get to 0, I'm done. Oh, I see. Oh. I just keep talking until it's shut up. Thank you. I'm sorry, I just want to get a couple of these things. Go ahead.
Supreme Court of Florida is now in session. Please be seated.
I'd like to begin, if I might, with the correcting a representation by the opponents that is just factually wrong. They argued that it was undisputed that we had not paired any returning senators in our plan. We have no idea if that's true. This court asked them to support that accusation. They provide.
I'm sorry, we need to have the time reset. Yes, we're into rebuttal now. Yeah.
So the first point is there's absolutely no evidence in front of this court that we did not pair any senators. The court asked them specifically to support that. They provided 5 names of senators. Obviously, they didn't provide the other senators.
On that question, I know we talked, and we didn't really get into much on the challengers about the numbering. In terms of doing the numbering so that you were able to be, in your words, equitable, didn't you have to know the addresses of all of the incumbents?
No, we just need to know which districts. No, not the addresses. I mean, in other words...
Well, you would have to know what districts they were going to be in under the new plan, wouldn't you?
No, you don't have to live in the district that you're running in. And, for example, they're wrong about Senator Latvala. As I understand it, he's running in a district that would enable him to be on a par with everybody else. But there was no incumbency addresses, and in terms of the pair point, which I'd like to get to, they argue that this could not happen naturally, not putting two senators together. I would really encourage the court to look at G3 of their appendix to their brief, where they walk through their plan, and they tell you where the population went from the old districts to the new districts. And it's very important to notice that they don't have one pair of returning senators in their plan. They've got 4 pairs, but always one of the senators is term limited. So if you just followed what they view as a neutral view of people who are trying to disrupt the status quo of the natural growth of that, you would not wind up with any pairs. So the notion, these are big districts, the notion that inevitably you're going to put people together is simply not true. As far as we can discern, and admittedly we're sort of piecing this together, they've got 3 pairs in their plans, each one of which is harmful to a voting rights thing. We've already discussed, I believe, the Orlando pairing, which disables them from creating a 50.5% Hispanic VAP district. I don't know where the proponents are getting the notion that it's got to be 50% citizen VAP, nor do I have any understanding of how they're calculating citizen VAP.
Did you, one of the questions asked on that was did the Senate do a functional analysis of all the districts in accordance with the Department of Justice guidelines?
We've scrupulously followed the Justice Department guidelines. Please read what they say in the quotation from their brief. You use VAP as an important starting.
So what I'm just saying, so that information was it in the Senate software? I mean, how can we? They said no, you didn't use it, and we were supposed to ask you how you used it. How can we look at the record? Let me just finish my questions.
Sure.
Makes it easier. And look at the record and tell that you that the Senate, not you, performed a functional analysis of the districts.
I didn't mean to interrupt you. I was just trying to clarify. When I was talking about functional analysis, when under the Justice Department guidelines are you supposed to do a functional analysis? When you have cognizable serious reductions in VAP. Well, what we had, for example, in District 6, what we're talking about, we had a finding from a federal court that anything below a near majority would disable blacks from electing their candidates of choice in Martinez. We had a proposal from the NAACP with exactly the same black voting age population that we recommended. And third, we knew about, vaguely, although they came in at the 11th hour, this new alternative where you would take it down to 42% and keep it in Jacksonville. But they didn't provide any kind of voting rights analysis that would not diminish the ability to elect. But more importantly, you only reduce VAP if you are going to put the excess somewhere that helps blacks either influence or be able to elect the candidates of choice. And the point I was trying to make before was, what do they do with, when they shave the VAP down, what do they do with the black communities that they've cut out of the district? That district we inherited and that we had to continue the ability to elect. They shove them into 90% white districts where they're not going to have any ability to form
well, you're assuming that a 90% white district is going to be Republican.
No, actually I'm not, and I didn't mean to suggest otherwise. First
you said they would have no influence, but if you put 9% on 45, 55, there's some influence.
Okay, that's first of all, when we're talking about district 8, they have no chance. It is a purely Republican district. District 7, I think, in their view, is a toss-up district. Point I'm making is, when we're talking about the ability to elect your candidate of choice, we're not talking about the ability to elect a white Democrat. let's face it, we wouldn't have needed the Voting Rights Act if the idea was that you could elect white Democrats in the South. The case law is quite clear. You need to be able to elect either a person of your race or of the other race. And that they are not alleging, and is highly improbable in a 10% black district, that you could elect a candidate of choice, whether he be black or she be black or white. And that's what the Supreme Court is talking about when they're talking about these coalitions.
The reality is, in the black community, since by definition and by fact we are minorities, and if you just were dependent on black people electing somebody that would be representative of them, it would never happen. So there has to be some collaboration with blacks and whites, and maybe you might not get the one in your choice, but you get the lesser of the evils.
There's a perfectly reasonable political science viewpoint, Your Honor. But the key decision that they made in 2006, the 2006 amendments that Justice Pariente has been referring to in Section 5 is, if you're in a position where you're able to elect a candidate of choice within your own group, you can't diminish that ability to elect. In other words, you can't be in a situation where I've gone from independently being able to select a candidate of choice to being dependent on attracting other people. No one is arguing that's a bad thing, and when we get to the Section 2 part, when we're talking about creating new districts, I think that's generally what we're talking about. But as with respect to existing districts, Amendment 5 made it quite clear you are going to freeze the ability to elect as of the time of what we inherited. We could have never reduced this district that we're talking about in a way to 42% and had any kind of showing, particularly in the face of the Martinez finding, that we had not diminished the ability to elect. At best, it went from an eminently safe district to a competitive district. And while competition may be good in political science literature, it's not good in terms of diminishing the ability to elect.
So you think, I just want to make sure again, because I appreciate the answer, and I think I understand what you're saying, but on what Mr. Mills said about looking and to see whether the Senate did a functional analysis of all the districts using the criteria of the Department of Justice criteria, where could you point us in the record, not your argument on it, but that it was done and done in a way that is consistent with the Department of Justice analysis?
Yeah, and to be consistent with the Justice Department analysis, you use VAP not as a be-all and end-all.
Excuse me. It's a very simple question. She's asking you where in the record is it shown that that was done?
Unfortunately, Justice Lewis, I think we're talking about two different things.
Okay, well, maybe you are. Then you all need to get on the same page.
I'm asking,
I understood her question.
So maybe I should begin from the back end.
Okay.
We did not sit down and do a racial bloc voting analysis that looked at exogenous elections. We did have, obviously, we knew that in this district, for the past 10 years, they had been electing a black candidate of choice.
Now, how do understanding, what is there, not what you know, because you may have had conversations with your clients. I'm asking, so the answer really is that there was not a functional analysis which doesn't just take voting age, but it also looks at political data, voting patterns, in order to ensure that we're making an intelligent decision about what value we are preserving when we say that the Senate was most concerned when they drafted this plan on protecting blacks and Hispanics. What do we look for to make sure that that appropriate analysis was done in the record?
That the principal advocacy group for blacks in Florida drew us this district. Now, presumably, they could not have had any kind of pro-Republican motivation. And I just want to clarify, the Justice Department guidelines do not require this racial bloc voting analysis unless You are reducing the VAP such that you have to prove to them that notwithstanding the reduction, we have maintained the ability to elect. That's what the Justice Department guidelines. And since there was absolutely no reason to reduce the VAP in terms of creating influence elsewhere, since Martinez had told us that was extraordinarily risky, and since the preeminent civil rights group in Florida told us this is the way to draw the district, as well as the incumbent up there who was on the committee, supported this plan, we felt what good would it have done to run a couple of sheriff's races from Jacksonville to come up with some number? So, and that's the only time the Justice Department wants you to do it. So I just wanted to alleviate that confusion. And that is the key point. They keep saying that this false voting rights theory is the linchpin of our gerrymander, and if I can convince you of anything, I want to convince you of the fact that we didn't make this up. We would have been subject to extraordinarily serious legal disenfranchisement if we had tried to do what they want us to do. I also want to correct the note.
Let me on that, because Mr. Mills makes a point that the question is this to be interpreted that forever in non-covered jurisdictions that the percentages can never change, even if it's a country that ends up having now elected a black man as president, even though we've got a small percentage of a minority. Is it that that's locked in now forever and ever, even though it's not required under the Voting Rights Act?
Well, there are constitutional challenges pending in the Voting Rights Act on precisely that theory, that Congress made a big mistake in 2006 when it did lock in these districts. The short answer is they're not locking in the VAPs. What they're locking in is the ability to elect. And I'm sorry, but I was just trying to make the point. As racial bloc voting is reduced, which we all hope will happen, then the reduction can come down. We were scrupulously looking at, the record is replete, is there some evidence of that going on here? Is there some indication that we could run this extraordinary risk that they want us to do? We did not adopt their view of things, which was reduce the voting age population as much as possible, as long as there's some evidence that minorities can continue to elect their candidate of choice, because of compactness and boundaries, because we thought Tier 1 was clearly superior to Tier 2. They want us to roll the dice on minorities being reelected to the Senate or creating historic new opportunities like in Orlando because of Tier 2. I don't think that's a rational reading of what Amendment 5 is about. You satisfy yourself on minority voting rights, then you go on to the next step. And I think they have it precisely backwards in a way that I can't emphasize too much is going to endanger what everyone would view as not some mechanical view, but real vibrant opportunities for minorities to elect their candidate of choice. I would also like to briefly mention this notion that it is true that we did look at geographic boundaries, and I know there's been a lot of questions about Districts 1 and 3, but I do want to emphasize that it's not as if we ignored political boundaries. Again, please look at D2 of their appendix. The difference between us and them is they kept 375 cities whole, we kept 362. Notwithstanding all of these voting rights issues that we've already talked about, and notwithstanding that they went out of their way, for example, to keep even non-compact cities together. So the differences here, I don't want anyone to think that they're major or important. We were very scrupulous about doing that as well. In terms of this Orlando situation, I do want to correct the notion that it has to be 50.5% citizen voting age population. As I understand Bartlett, it needs to be 50.5% voting age population, and I'd encourage the justices to read the brief to see that that's correct. There's one final point on the Voting Rights Act, which is probably more obscure than you would think. The way they come at Dade County, which creates all sorts of complications and some of these pairings, is a facial violation of Section 5 of the Constitution. What they did was not wrong in terms of they created Hispanic majority districts, that's fine. But what they did take was protected black communities in Collier and submerged them into the Hispanic Republican majority districts in Dade, in District 38. They also took protected black citizens from Monroe County and put them into Hispanic majority District 39. The legislature got a Section 5 objection from the Justice Department last time, even though the Justice Department said, look, the districts are fine, but the people from the protected counties, if you just look at the counties themselves, have been diminished in their ability to elect. In other words, it's not minorities throughout Florida have been hurt, but you need to focus specifically on these minorities counties, and that's a very important specific point. Unless there are further questions, thank you.
Good afternoon. May it please the Court. I'm Alan Windsor on behalf of the Florida House. I want to respond to what I view as a little bit of a changing argument dealing with the partisan proportionality. As I read the briefs, the allegation, as I understood it, was that the Florida House had manipulated the district lines with the unlawful purpose of favoring Republicans. We obviously strongly dispute that. But now I think the argument has changed to something a little bit different, and I'm pleased to hear Mr. Mills say that they do not allege illegal or evil intent. As I understand the argument now, it is that because of residential patterns that would, as a result of fair redistricting, as a result of redistricting in compact and contiguous districts, would have the natural result of favoring Republicans, that Amendment 5 obligates the Florida House to go back and redraw the lines to change them to make more Democrats able to be elected. We submit this is not only an incorrect interpretation of Amendment 5, but it would actually violate Amendment 5. If, in fact, a naturally drawn map is going to favor one political party, and dissatisfied with that political result, the Florida House went back and redrew the lines with the specific intent to equalize or change the electoral outcomes, that would plainly be intent to favor the political party that was otherwise disfavored and disfavor the political party that was otherwise favored. The argument can't work, and there's a completely independent second reason, and that is because even though all the discussion today has been about the statewide map in the aggregate, this many Republicans, this many Democrats out of 120, if the argument is right that the House had an obligation to go back and manipulate the lines to achieve some sort of partisan proportionality, that would be true not only for the map as a whole, but for each individual district. And that's because Amendment 5 talks about no apportionment plan or district shall be drawn with an intent to favor or disfavor. So you'd have an obligation to essentially draw 120 50-50 districts, which is simply impossible with respect to the Tier 2 criteria. As the Court pointed out, there are differences throughout the state. In Panhandle, people tend to vote one way. In Broward County, as another example, there's a 2-to-1 Democrat registration advantage down there. So how would the House draw a Broward County district? The answer is they couldn't. I also want to talk about the equal population issue, and Mr. Mills has suggested that the nearly as practicable language in the Florida Constitution is somehow different than what existed before. The nearly as equal as practicable language is directly out of Reynolds, which interpreted the Equal Protection Clause of the federal Constitution. It's exactly like what it's the exact case this Court relied on in 2002 and earlier.
The way I see the difference, though, and see if you agree with this, that the difference is that before 2010, there were no other constitutional criteria other than contiguity. And that now, and as I read the cases out of the U.S. Supreme Court, once there are constitutional criteria, the reason that you can deviate is in order to satisfy another constitutional criteria. And how do you, so therefore it's not different in terms of what might be the acceptable deviation, but it's different in terms of what might be the acceptable justification. How do you respond to that approach?
Well, I think with respect to all of the Tier 2 criteria, there's a balance. And when you deviate from one, there needs to be, accordingly needs to be a balance in another one. To the extent that there is population deviation, and plainly there may be, otherwise it would be a Tier 1 criteria. If it were a zero population deviation like we have in the congressional, it would not only be a Tier 1 requirement, but it certainly wouldn't be, it certainly wouldn't say there's no priority among the Tier 2 criteria.
I'm not sure I got my answer. My question was, is it looked at any differently because it's now the other constitutional criteria are in the amendment restricting how the legislature can draw than before when there were no other constitutional criteria?
I don't think so, Your Honor. And I think, if anything, it would be the opposite, that there could be more deviation because there is now other requirements that have to be adhered to, like compactness.
My point is that those are the only bases on which they can deviate is to fulfill another constitutional criteria.
Yeah, fair enough, Your Honor. And as applied to the House map.
I hate to say this was a friendly question because Mr. Merrow said he didn't want to accept that, but it's sort of a friendly question, but it was just trying to...
He said he'd be the judge of it.
Thank you. And I think that's a fair point. And Mr. Mills suggested that when you do have a deviation, there has to be a reasonable need for it. There has to be a reasonable justification. I can tell you with respect to the House map...
Do you agree with that statement? I wonder if there's anything we can get agreement on. Do you agree that there has to be a reasonable justification within the Constitution for the population deviation?
I agree that there has to be a balancing of the Tier 2 criteria. And what you see in the House map...
When we look at the language with respect to the equal population, that language is borrowed directly from Sims.
That's right.
I mean, and so we would have to understand that a reasonable voter would understand that that's part of the legal framework within which that provision is going to operate. So to come up now with a more restrictive test than the test that had been applied using that same language would seem to me to be doing violence to the language of that text.
I think that's right. I think the additional restriction comes not from including that provision in there, but including other provisions as well, the compactness and the compactness and the political boundaries. And as applied to the House map, what you have is the highest deviation is in Charlotte County, and that was done to keep Charlotte County whole. If you had closer to mathematical precision, Charlotte County would have been divided. At the other end of the spectrum, the lowest deviations are the districts that are in Lee County, where you have 4 districts put together making up the county. And again, if you increase those, then you'd have to spill over outside of Lee County. So certainly with respect to the map, there was a logical explanation for every
and again, a rational explanation within the constitutional criteria from the
That's right.
House.
That's right. It's a balancing.
Do you, if we were... I noticed several times in the House brief that the House mentions the severability. If we decided that the Senate map has problems in terms of the constitutional criteria, but the House, because the approach was in some ways different, do not suffer from the same problems, do we have the option of only invalidating part of the joint resolution, the Senate plan and not the House plan?
I believe in that circumstance you'd have more than the option. I believe you'd have the obligation, and that was the legislative intent, was to have the severability clause.
Because the House really didn't. The way it worked this year is that the House left the Senate alone, the Senate let the House alone, and they both agreed that whatever they passed would then go out on the joint resolution.
Well, the entire legislature adopted the joint resolution, so it is the legislative product.
Is it not the case that there was no debate in either house on the other's map?
No, the legislative record reflects that each map originated in its own chamber, but
without any debate. I mean, the House didn't debate the Senate map, did they?
I don't believe so, Your Honor.
Well, you know so that they didn't, and the Senate didn't debate the House. If it goes back, but the House has to, any joint resolution needs the assent of both houses, correct? So you can't.
Absolutely, Your Honor. Yes. Yes, there would be a new joint resolution that would, just like this joint resolution, would follow the constitutional requirements for a joint resolution, which includes passage by both houses. I'd like to talk a minute about the racial provisions and the statement that the opponents have made that the House did not do a functional analysis with regard to the racial the minority districts is just plain incorrect. They absolutely did, and as a result of that, they ensured the protection of minority voting rights. They ensured that in no district would there be a diminishment of the minority's ability to elect.
How did the House go about that?
The House went about that by looking at political data, registration data, and things like that to with respect to the individual districts. And in fact,
that's in the House software, that political data is in the House software, and correct?
It is in the software, Your Honor, but they also looked at county data that was outside of the same system. And if you go back and look at the legislative record, you'll see where amendments were made specifically to address areas where, absent the amendment, there could have been a potential diminishment. And you see also, when you're talking about a functional analysis, when there was debate on the league plan that was in front of the House of Representatives, that was a feature of the debate, was the analysis that long before their expert conceded that it would have diminished Hispanic voting rights, the House identified that during the debate. And that was one of the reasons that it voted 21-0 in committee to not adopt the league's proposal. Related to the racial districts, another suggestion has been that the House was locked into the percentages and that the House did not reduce any voting age percentage of minorities in the minority districts. That, again, is factually incorrect. It's clear from the record that there were some, for example, 60% African-American districts that were reduced into the 50s. A result of that was the addition of a new majority-minority African-American district that didn't exist in the benchmark plan.
But you did not reduce it in places where there was not an opportunity to create another minority district. Is that correct?
I'm sorry?
Did you reduce the voting age population in existing minority districts in the absence of an opportunity to move those excess voters over into a new minority district?
Well, I'm not quite sure how to answer that question. There was, as a result of the reduction in Central Florida, for example, there is now a 40% African-American district that will provide an opportunity to elect in Orlando that adjoins what had previously been a much higher rate, but now is reduced into the 50s. Overall, there's an additional majority-minority district. What the House did not do is it did not take any existing 50% plus minority district and reduce it under 50%. So the House ensured the preservation of every majority-minority district.
Was there any performing minority district where you reduced the percentage of the voting age population percentage?
There were some majority districts that have reduced population, but they all will still perform. That was the House analysis. But again, and in fact, by reducing it, it provided the opportunity for a new additional district, additional African-American majority district, and some additional Hispanic districts as well. So this allegation, that in and of itself disproves this allegation that there was racial packing going on. In fact, there was, if anything, the whole purpose of having a Section 2 prohibition against packing is to prohibit putting too many minorities of one district to the exclusion of another majority-minority district.
You know, one of these things that you look at, because you mentioned it was 21-0, that it was passed out, and I don't, you know, and the Senate said that they follow the NAACP plan. In the House, it looked like, and correct me if I'm wrong, that the Black Caucus voted unanimously against the House plan. Is that correct or incorrect?
That is correct. There was unanimous opposition of all Democrats in the House to the House plan. But if you look at that, is not to say, however, that what the House map does with respect to African American districts is disadvantageous to African Americans. And quite the contrary. If you look at our appendix to our reply brief, we have examples there of every African American minority district with what the House map drew right next to what the NAACP proposed, what the NAACP asked the House to draw. And they had very similar looking districts. They're not identical, but if you look at the way they believe that African Americans should be protected, it's perfectly consistent.
So you're saying we should defer to the NAACP as opposed to the black elected officials?
I'm not, no, Your Honor.
You're saying that you're speaking as if that trumps the elected officials who are representing those districts in terms of their opinion of this plan.
I'm not saying that at all, Your Honor. What I'm saying is, and first of all, you can't, political opposition to this plan, the fact that this was not unanimously adopted in both chambers does not speak to its constitutional validity. There are political opponents to it. There are opponents to it in this court. But the only issue before this court is whether it's constitutionally valid. And it is. But my point was that...
No, you're the one that said that I keep hearing this over and over, that the top group representing blacks approved this. So, I mean, that's what I was speaking to.
Well, I think
this is a constitutional issue, and this is the way we'll decide it.
That's right, but if the constitutional allegation is that we're packing African Americans into districts, but yet we're adopting recommendations essentially made by the NAACP, I think that's probative on that issue. But as the court there's been discussion about, the racial claims can't be resolved where there's a factual a need for resolving facts. Lastly, I see my time's running low. I did want to respond to this argument that's been made in the briefs and here that somehow the legislature just ignored Amendment 5, that somehow Amendment 5 wasn't a part of the process, and that it was just business as usual and just politics as usual. Nothing could be farther from the truth. Amendment 5 was front and center in this process from the very beginning until the final passage, and I think the proof is in the maps. If you look at what the House map has done, it's clear that they complied facially in every respect with the federal and state constitutions, and would ask the court to uphold the map.
All right. We thank you all for your very able arguments. The court now stands adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.